Okay, we now have a quorum and we will begin the COPRAC meeting. This meeting is being recorded. Before I do the roll call, we ask that anyone who plans on giving public comment to use the raise hand function to indicate that you'd like to do so. Now, with permission of the chair, I'll take the roll call.
Yeah, please.
Justin?
Here.
Ken?
Here.
Sarah?
Here.
Elizabeth? I believe Elizabeth's here. Cassidy Chivers?
Here.
Toby Inlander?
Here.
Brandon Kruger? Joel Mark?
Here.
Eleanor Mercado? Bill Munoz?
Here.
Dina Roach?
Here.
Kyla Rowe?
Here.
Hunter Starr. All right, thank you.
Do we have any public comment today, Mimi?
Don't think we even have anyone here from the public today.
Well, they're missing out. All right. So I see next on the agenda is announcements. I guess. Do you want me to talk now, or Randall or Mimi, do you want to report on anything?
You can go first, and then I will follow with an ethics symposium report, and then Randy can do his bit during the staff report.
Okay, I was just going to say something about the symposium. So why don't you go first, and then if I have anything to remark after, so be it. Okay.
So we had a total of 472 attendees, and we got a lot of good feedback back in the evaluations. In case you get questions regarding whether the symposium will be available for viewing at a later date, currently we have no plans to post or share that video. It may become a self-study in the future, but as of right now, there is no plans. And also, I'd like to say this is probably one of the best symposiums we had based on the evaluations that I've reviewed, and along with noticing how many people did not drop off in the last panel of the day. Typically, the last panel, we have quite a few people. I would say maybe 90%, if not 95% of the viewers actually stayed on all the way till the end of the day. So that's actually pretty impressive. And that's all I got.
I noticed that too. I was waiting for the number of attendees to drop as we started the fourth panel, and it just stayed steady, and that was great. I mean, that was such a solid panel, interesting, engaging panel to have at the end. So I think that really helped. So I just wanted to say thank you to everyone who, both the State Bar staff and our members who participated in the symposium. It's a heavy lift, and we really appreciate it. And I think the feedback that we got from the attendees and the participation numbers, I think, reflect that we're, notwithstanding our remote viewing experience, we're still putting good product out there that people are interested in. And so maybe we'll do it in person next year, but if not, I think we've got a good routine down here, and it seems to be effective. So thank you all. Okay, well, why don't we go to any other staff report for Mimi or Randall?
Yes, staff report from the Office of Professional Competence. As we all are well aware, we lost our supervising attorney in the Office of Professional Competence earlier this year, who's one of his primary assignments was to serve as staff counsel to COPRAC. I am very pleased to announce and to welcome, you might have noticed her in the Zoom windows, Erica Layton, who we have hired to be a new managing attorney with the Office of Professional Competence. She will be assuming Andrew's former responsibilities as staff counsel to COPRAC. Her start date will be June 13th, so she is not officially available yet to us, but she's attending today and will be attending the meeting next month as well. She comes to us from the State Bar Court, where she has various duties, including being the project lead or co-lead on many of the State Bar Court's projects. She prepares agenda materials for State Bar Court matters. She drafts proposed rules of procedure and practice. She issues internal advisory memos and policy directives. She trains the State Bar Court staff on the rules of professional conduct, advises the State Bar Court judges and attorney staff on judicial ethics. And previous to that, since we wanted someone who could hit the ground running in helping COPRAC, Um, Erica has served as the Supreme Court staff attorney for the California Judicial Ethics Opinion Committee. So she has experience directly serving a legal ethics opinion committee, in this case, judicial ethics, managing, overseeing all of their practice and procedures, developing ethics presentations, preparing press releases, responding to media inquiries about CJO opinions, and maintaining their CJO website. Before that, she was in State Bar's Office of General Counsel, and she actually started many years ago with our office, the Office of Professional Competence, where she was mentored by Andrew and prepared petitions to the Supreme Court on the new and amended rules of professional conduct and worked on the ethics hotline. I think I mentioned the leadership in an email that I'm of course going to miss Andrew, but of all the options we've looked at and considered for filling the void he's created, I cannot think of anyone other than Erica who would be my first choice for coming on board and taking his place. I hope you'll join me in welcoming Erica.
Thank you.
Welcome, Erica.
Yeah, we're very excited to work with you, Erica. And I mean, talk about an encomium to start off right here. And we're very appreciative that you're going to assume the responsibilities as you know our support staff here at COPRAC. And you know, I think you're going to really help us over the next hopefully months and years. So welcome and thanks for being here today.
Very well, thank you for having me, and I'm here to learn today. And thank you, Randy, for that lovely introduction. And I'm excited to meet all of you a bit more and work with everyone. So thank you.
Great. Well, anything else from the State Bar staff?
Only one other note. We continue to monitor legislation concerning the bag leaking requirements for open meetings. Unfortunately, we don't see anything on the horizon that would suggest that there would be a change, certainly not in time for the June meeting, but we continue to monitor the situation.
Thanks for the update on that. Certainly an issue we're all interested in. So unless there's something else, why don't we go to approval of the open session action summary from February?
Can we get a motion to approve the action summary from the February meeting?
Motion. I move.
Second,
Is that Ken?
yes.
Okay, thank you, Ken. All right, we'll take the vote. Justin Fields,
Yes.
Ken Bacon,
Yes, approve.
Sarah Bonola.
Yes.
Thank you. Elizabeth Bradley,
Yes.
Cassidy Chivers,
Yes.
Toby and Linder. Brandon Krieger, Joel Mark,
Yes.
Eleanor Mercado, Bill Munoz,
Yes.
Kyla Rowe,
Yes.
Hunter Starr. Thank you.
Okay, great. Well, first up, we have the ethics of working remotely. We're just going to talk about, I think this, and I'll let Sarah introduce it, but at a very high level and maybe a specific issue here or there. And then we'll have a more fulsome discussion once the public comments are finished coming in. Just as a general note today, I just want to thank everybody for making the extra effort, particularly for those of you who had to travel for this meeting. Dina, Sarah, and I talked in advance, and we know this is also a schedule adjustment for everyone, not just those who traveled today, because we didn't plan on having a meeting in May. So we're going to do our best to finish at a firm time of 4 o'clock today, so that all of you that had to travel can hopefully beat some of that Friday afternoon traffic. And as Mimi touched on earlier, some of you might have heard, to the extent that we don't get into some of the opinions we perhaps would have otherwise gotten into, we have another meeting in a few weeks, so we'll plan to put those on the agenda for our June meeting. And with that, why don't we turn to 2020-004. And Sarah, if you just want to kind of introduce where we are in terms of the public comment and what you'd like to discuss today, and then we'll go from there.
Sure. And we received the second round of public comments because we sent it out after we made revisions in response to the first round. And the deadline for those public comments was May 4th. So we didn't have a chance to put together a summary and analysis of public comments or make any revisions by the assignment deadline for this meeting, but it will be addressed more thoroughly at our next meeting. Although the public comments that I did receive so far have been fairly limited. And I do think there are a couple minor changes that could be made, but I just wanted to raise one issue for the group's discussion. And it was raised in the comments from the Orange County Bar Association's Legal Ethics Committee. But it reflects kind of comments that we received from both the first and second round, where, you know, the majority, I'd say, of the public comments are concerned about the fact that COPRAC does not address unauthorized practice of law issues in connection with working remotely. And, you know, previously we had explained that in a footnote, and because a lot of people had overlooked that footnote when we revised it in response to the first round of comments, we put it in the body to make clear that COPRAC does not opine on unauthorized practice of law issues. But the Orange County Bar Association seems to understand that now that it's in the body, but they are still asking, is that something that can be explained in the opinion, why that is, why we don't opine on unauthorized practice of law issues? And given the kind of the overwhelming feedback we've received and concern from even the second round of comments, I think one or two, we didn't receive many the second time, you know, expressed concern that we're not addressing that issue. So I wanted to raise it for the group, not that we're going to revise it now to address it, but if we should explain in the opinion in any way why we do not opine on unauthorized practice of law issues. And I'm not sure I clearly understand. I realize that's a policy from a while ago, and it deals with, you know, we don't generally address issues of law as a committee, but I just don't know if others feel that that's something that we should address, maybe in a footnote after we say we don't opine on this. But I'll pause now and open it up to the group.
This is Cassidy. I think probably the factor in favor of explaining why is the fact that there's so many other state bars that do, you know, and it's confusing for lawyers who see, you know, and in articles and you know, it's definitely out there. And so I think there should be some brief explanation based on that, because it's not a common policy nationwide.
Yeah, I know we went kind of back and forth on this and wrestled with it a little bit. And, you know, I know Andrew had sent us some materials that it was from something from the board from like 1989. And I just wonder if, since we all can acknowledge that the legal landscape has changed so much since that time, if that's something that the committee, not necessarily for this opinion, wants to consider talking to the board about with respect to this particular issue, which is the, you know, sort of physical presence versus legal presence issue, and not talking about opining on whether other contexts of UPL, because that discussion that a lot of bar associations and other state bars have now opined on, including the ABA, is something related to the evolution of the way we consider practicing law. This is changes that are inevitable and are part of the practice, and is not, it's really more of an interpretation of 5.5, which is a legal ethics rule, which is something that we do, as opposed to, you know, getting into like the legal definition of what is UPL. So, but I know that, you know, maybe Randy can speak more to that. I know that that's something that once upon a time, the Board of Trustees, you know, didn't want that to be something that the committee opined on. And I think, I don't know what the issue particularly was in front of them at the time. I imagine it involved wildly different facts, right? Related to what, you know, because UPL is a huge umbrella, as we know. But I just, you know, just something for the committee to think about. I'm not really sure what I think about how to address that here, Sarah. because it would involve that kind of complicated explanation that the Board of Trustees once upon a time said we can't do it. I think it would be important to probably this committee and sort of the future of law to really sort of unpack whether that's really what they intended for what the legal landscape is like right now. And it's not going to change and revert regardless of what happens with, you know, the evolution of the pandemic and stuff. I mean, this type of work is just, it's here to stay. It's part of becoming, you know, as a national and all kinds of industries, as we all know, it's not just impacted the legal world.
Yeah, Dina, you hit on a number of important issues here, and you know, I agree with how you feel about these and your thought process in terms of maybe us needing to find out if the State Bar Board of Trustees or whomever still feels the same way that they did in 1987 or whatever it was. And so I kind of see two avenues here. As for the opinion itself, you know, assuming that the policy hasn't changed or we're not going to receive an update on the policy before this opinion is finalized. In terms of the concerns that have been raised about, you know, what that policy is and where it comes from, and the readers wanting clarity about that, I think we should at least draft up some kind of footnote in this opinion that maybe explains very concisely why it is we do not opine on these issues, but keeping in mind a discussion we had earlier, which is that if and however we explain in a very concise way that why we don't opine on UPL, one of the things we struggled with earlier was that it came across sort of critical of the State Bar, and perhaps we have our own personal views about whether we should or should not opine on UPL. But I think whatever we draft, we want to just keep it neutral. You know, here's the policy, here's why we don't opine on UPL, and keep it simple like that on, you know, around that section 5 in the ethics of working remotely. So I think, you know, step one is let's draft something short and neutral to explain the policy in a footnote where we talk about that the committee doesn't opine on these issues, or that it's beyond the scope of what this committee opines on. I think that's sort of track one, and then we can talk about in our next meeting, you know, the proposed language for that footnote, or whatever it ends up becoming. But then I think track two, and if I'm overstretching what you said, Dina, you know, tell me after, but I do think that it is worth an ask to the Board of Trustees about whether or not their views on UPL have changed. And I don't know, and I'd be interested in Randall or anyone else from the State Bar's feedback on this kind of process-wise, how we would want to raise that question. But if their view hasn't changed, they really don't want us talking about UPL in any way, shape, or form, okay, let's confirm that, because this issue comes up every calendar year on some opinion when we're talking about whether, you know, the UPL issues that might touch on it. So I think it would be helpful to know sort of what is the current lay of the land, given the landscape, as Dina said, has changed over the last 20 years. And if their views have changed, great, then that might inform how we go about addressing that issue in the future. If it hasn't changed, so be it. We're where we are today. But it seems to me that a polite ask in the appropriate way here is not is appropriate, and I think would serve you know, the purposes of this committee and the scope of what we should be talking about in our opinions.
Justin, let me just mention that staff will begin the internal conversation on how to revisit this issue with the board in terms of the policy directive to COPRAC concerning issuing opinions that address the topic of unauthorized practice of law. It was a legal analysis that was presented to the board at the time in regards to anti-competitive issues and the limitations of the state action exemption. Many things have changed for the State Bar since that time, so I think it is completely appropriate to revisit the issue and see if there might be an updated legal analysis and a different policy decision perhaps from the board. So we will definitely begin looking into that for you.
I appreciate that. We want to be respectful of what was analyzed in 1980 something, but also, appropriately ask the state bar if this is still the route they want to take, and they may have good reason for maintaining the status quo. They might feel very differently when we raise the issue and explain the concerns that have been raised to us. And so perhaps at our meeting in June, if we could have an update about the proposed process, or at least what you're thinking tentatively about what the process should be for us to make the ask, or perhaps for staff to make the ask of the state bar. We want to do it in as polite, respectful, and procedurally appropriate way. So I think if that's a conversation we could put on it for our agenda in June, I think that would be great.
Okay, that sounds great. And I will work on drafting a footnote, since it seems like that's, out of the members who have spoken, that people seem in favor of adding a footnote explaining the issue very briefly. And I'll share it with the subcommittee members in advance of our next meeting, and then share it with a larger group at our next meeting.
Sounds like a good plan. Any other comments or observations about the UPL issue, asking the state bar about it, inserting some kind of comment in the opinion? Okay, well, then we're done with our discussion of 20-0004. So we'll keep moving along and see how this goes. I think Brandon is not with us yet, so why don't we skip over the contingency fee agreement and talk about the succession planning opinion 20-0002. Let me give folks a minute to pull that up. And Dina, maybe you could give us a refresher on this opinion. It's been a while since we've had a chance to talk about it, and what changes, if any, that have been made since we last discussed it, and any other questions or comments you want to flag for the committee.
Sure. Thanks, Justin. Yeah, it's been a while since it's been back on the agenda, and I don't think in terms of our new committee configuration, this is the first time we've discussed it with this group. So a couple comments about it is that hopefully you guys had a chance to read it. It basically deals with these three different fact patterns. The second one, which is much more fully fleshed out than the first and third, and that doesn't mean that the first and third need to have as much fleshing out as two, because there's a lot of unique issues with that, but it's definitely sort of still a work in progress. It's not meant to be that those two scenarios would just be 2 paragraphs long. That's something for us to discuss. I want to say at the outset, because my term as advisor is coming to a close, that I'm really looking for someone to step in, maybe more than one person, and take on lead drafting role with this opinion. So I'm hoping that after today's discussion, one or more people will be absolutely inspired to take on this, because it's a critically important issue. We've actually had people say that they want to have more, opinions on this topic. And it could certainly be broken down into more than one opinion, some of these issues. But we really sort of need a couple folks to step in, and again, one person to take on that lead drafting role going forward, so that I could be an advisor on it, during the remainder of my term. So I think the critical, some of I'll make some general comments. Besides the fact pattern issue, we talk about some general ethics duties that are implicated with succession planning. There are a lot of them, as you can see. So our question is that sort of the approach that we want to follow? As you know, there's not any particular rule that requires it. So a lot of these succession planning opinions from the ABA and other jurisdictions. And the ABA website actually has a great little section that I think we highlighted in a footnote, which they sort of have collected some succession planning opinions from different jurisdictions, and some jurisdictions have, very robust succession planning more like suggestions for lawyers and stuff, depending on how their bar associations approach those different things that have been endorsed by judges in various jurisdictions. So it's a very good like resource, which we're trying to sort of, replicate here in a way that makes it, obviously California lawyers would be able to look at this more readily and see some of these things. But so that's the approach there. And then of course, the second fact pattern deals a lot more with specific issues about whether or not, a particular lawyer that's going to take on assisting with succession planning with another law firm, and just some of the ethical considerations related to that transaction, of which there are more than people typically think of. So that's, again, more fleshed out, not that it can't be polished. And then the other sections are really, it's a question of like what direction we want to go with those. I mean, the first one sort of obviously, like the person didn't engage in succession planning. I don't, that we could look at that slightly differently, but that's a sort of a common scenario with the solo person who's disconnected and hasn't thought about that. And then we decided as a fact pattern, we really wanted to go towards like, dealing with it in the context of a middle-sized or larger law firm, a firm that's not a solo practitioner's firm that should think about these things, and what kinds of policies and procedures under 5.1 we could say, tying in these ethics rules that they should really consider as part of succession planning, knowing that it's hard to be very specific about like they need to do A, B, and C. We can't really approach it that way. So, but coming up with that kind of fact pattern was more challenging. So it was more that this attorney managing partner was like looking into whether that's something that the firm should engage in. Certainly open to different approaches on both of those, that fact pattern with the law firm. But the idea with the third fact hypo was just that it was going to involve a law firm and was going to implicate 5.1. So that's sort of the lay of the land. And I'd love to get feedback from people. It's been a while since we talked about it. So, there's not, there's not really fresh issues that we're addressing. And, I think we are kind of dust it off and get our brains back in it to try to finish it off. It's, has a lot of good things in it, I think. And so just going from there.
Well, why don't I kick us off? First of all, it just the structure of this, Dina, and kind of the way you write is, I just think, so constructive for these types of opinions. It reminds me a lot of the ethics of lawyers departing law firm opinion in terms of how you've structured and how you talk about the issues. And I just think it's very effective and clear. And this is already such a robust opinion as is. So I think this is in just amazing shape. I had a couple thoughts, and I'm happy also to take a more involved role as we try to finalize this. But I was thinking for scenario 3, that's, as you sort of noted this already, that's one that we could I think beef up a little bit. And one thing that I was thinking about as I read sort of the last page discussion of scenario 3 is we could add a reference to comment 1 to rule 5.1, which I think kind of really brings home what you've quoted already from rule 5.1, this idea that making reasonable efforts, as the comment I think explains, means as a practical matter, establishing internal policies or procedures.
Yeah.
And so that could then open up a discussion. Well, what type of policies and procedures should law firms have in order to ensure that they're protecting clients in the context of succession planning? And so I think that might be a segue for us to open up the discussion in the context of policies and procedures. And you have some questions in scenario 3 that kind of start that discussion. But I think given the kind of fleshed out nature of the discussion for the sole practitioner or small firm scenarios, that to the extent that we can add more of a balanced discussion on scenario 3, I'm in favor of that, and happy to try to offer further input. But that's what I was thinking for scenario 3, big picture. And with respect to scenario 1 and the analysis, I'm around, oh shoot, I'm on the clean version, sorry about that. But towards the end of the scenario 1 factual analysis, where it says, the penultimate sentence, as such, lawyer A should have had a succession plan in place. It got me thinking, and of course, now we're in the world of, well, practice pointers versus not using practice pointers. But the question that I had in mind is, well, what in this context would be an adequate succession plan? So for instance, would it have been enough for the lawyer to have had an assisting attorney in place, or would something more be required given lawyer A's practice? And I'm not saying that what the right or wrong answer is, but it seemed like there might be an opportunity there to, do that kind of dance we do where we offer suggestions but not make the opinion a practice pointer discourse. And what got me thinking of that as well is, you mentioned some of the, whether it was the ABA opinion or some of the other state bar opinions having a number of suggestions for lawyers. And if there are other suggestions that we think are really helpful and would be useful in this opinion, and we can kind of nimbly incorporate them without this making, sounding like a practice pointer opinion, I'd be in favor at least considering, offering additional examples of what lawyers should be thinking about in terms of succession planning, in addition to the very, I think, detailed and helpful discussion of assisting attorneys and the other suggestions along those lines that are already incorporated here. So those were my two kind of major thoughts as I read through this. But like I said, I mean, thank you so much for taking the laboring work today. And I think we all want to, help pick up the effort here and help to get this across the finish line. So hopefully others will also, after considering it, agree to join the subcommittee. That's what I have.
Thanks, Justin. Yeah, I agree with both of those points. And I think in terms of the suggestions for a lawyer A, they are kind of addressed in scenario 2, where it's like getting assisting attorney or having people know passwords, knowing where things are. Like a lot of those things are dealt with later, but they could be certainly here. Another option for A is that we don't say, oh, the person's been incapacitated and all these horrible things happen. We just say that this is the setup of the lawyer, and then what, have sort of the discussion deal with like these things that could happen, which would cause, I don't know. I think we went back and forth on that, but yeah, those are definitely helpful. And comment 1 should be included in the third part scenario. I like that.
I had a concern on that one. I mean, the fact pattern is such where, the lawyers got, in the hospital and missed a lot of things, but in the discussion part, once again, it doesn't really address that. When I read it, it seems to suggest that a solo practitioner has an ethical duty to have a succession plan in place. And that's a pretty strong statement. I'm not sure the rules are really there yet.
Yeah, I mean, that's the ABA's interpretation of the rules. I mean, with that quote, as you can see from their opinion, they've, relied on similar rules that we have for that conclusion. That's, just as a note, for a solo practitioner, it hasn't gone farther than that, but yeah.
So they say should have. I'd have to go back and read that 92 opinion. I mean, are they saying, as a practice recommendation, or that there's an actual ethical obligation to have a succession plan when you're a solo practitioner? Because that's
Yeah, I mean, this is where I think the challenge, Ken, that you've raised is what we talked about when we had this opinion before, which is it is a very delicate balance between ethical obligations versus best practices. And because the rules don't squarely say something, I think the language that we've used at sort of the beginning and the introduction have been carefully crafted so as to not say, that there is an ethical obligation for a succession plan, but it's also hard to read the rules put together and say that there's no obligation, right? That you don't have any duties to consider these things. And I think that so it sort of depends on as a committee how far we feel like we're comfortable going. And a succession plan could just mean, when you say those words, it doesn't mean maybe that you have to do like, here's the list of things you have to do, but considering, it's just like you consider when you're going on vacation, you're not going to just have no plan for like, what if a client wants to contact you? What if you get mail? What if you get client funds that come in? Like, you have to think of those things. I don't think anyone thinks it's okay to just take off and not do that. So that's a planned event, right? So the idea being that if something did happen and you were completely isolated, you would have yourself like, at least my spouse, like that would be a very low succession plan, but they have access to passwords or something, or I have a paralegal that can help, or I have another, person that I've worked closely with as a co-counsel on matters. And they could do these things if it required. I mean, a succession plan doesn't necessarily have to involve like a 10-page document of things. It's just thinking about how you're going to handle things for your client's protection. And maybe we can describe that a little bit more so that it doesn't seem so overwhelming when we use those words. But that's just a thought. But it is a delicate balance, you're right, between what is the ethical requirement versus like a concept of best practices. But this is, I think, so important to client protection that, it's a really important opinion.
And that's where I agree with Justin. I think some, examples or discussion of what might be, or should be some kind of a succession plan, and nothing else goes to the access to the passwords and all that. But yeah, because the concern I had, stuff happens. You're driving to work, you get in an accident, you're a solo practitioner. Have you now committed an ethical violation if you didn't have a succession plan, a totally unexpected event? I don't know that we really want to go there. So that was my concern on that one. But kind of a similar thing was on page 8. Duty to communicate. Yeah, that first line, 280. If lawyer is unable to communicate practicing law permanently or for a period of time, that's a significant development. The period of time part I thought was kind of vague. What does that mean? And if you're going to out for a week having a minor surgery, do you have to communicate that to your client? I suspect that would generate some public comment there, because it really is pretty vague as to, what point does that trigger? If you've got some health concern or whatever, that you have to notify the client of that.
Yeah, I think that's a good point. I think that certainly permanently is a significant development. The period of time is fact specific and dependent, right? So maybe we can kind of like clarify that a little bit more. I was going to say we could say extended, but then it could be a week, could be significant to a particular client who's expecting you to do something that week, right? Related to their matter. So I think that would be really fact specific.
Yeah, well, I'm not saying this needs to be wordsmith, but I think we want to maybe tie period of time to the concept of time that would impact the representation in some way, right? So if you're just on a two-day vacation on Saturday and Sunday, and you're a litigator and the courts aren't open, maybe that's not going to impact the representation. So maybe want to tie it to some kind of concept like that, as we think about it.
Yeah, can you write that note in there, Mimi? Significant to the representation or impacts the representation? Because I think that's a good clarifying point. Yeah, those are good points.
Well, to me, the significant event is not the period of time, it's the foreseeability of prejudice to a client. And that could depend on an hour to a year. I don't know. So I think that's where the focus ought to be. Which, as somebody said, is very fact specific to an individual practice. But
yeah, I think
that's an important factor.
Yeah, I think if we tie it to impacting or foreseeable prejudice rather than just an unspecified period of time, that clears it up, or at least gives a bit more guidance.
Yeah, Agreed.
The other comment I had was on page 5. Up at the top, lines 141 to 143. Duty to communicate imminent retirement or unavailability to practice law if known. I don't necessarily disagree with that. I just wondered whether it was too strong, and maybe Randy or somebody can correct me on this, but it's my understanding, at least in discipline cases, if you have a suspension, unless the Supreme Court under whatever it is, Rule 9.2 or something like that, says you have to disclose that to your client, you don't necessarily have to disclose that to your client, even though you're unavailable to practice law. And in my experience, they don't always do that. So I just question whether that might be too strong a statement that, any unavailability to practice law must be communicated to the client. I mean, I personally think it should be, but I don't know that it's always required, at least in discipline cases.
Yeah, that's a good note too, Ken. We can look at whether we say would likely, or again, it would be like the fact dependency, and the unavailability to practice. I think it depends on how it would impact that client. It's a sort of similar concern. Yeah.
I think that's all I had.
Thank you.
And I can jump in on this one too, so you guys need to know.
That's great. Mimi, can we add Ken to the subcommittee?
Okay, will do.
I did have a question, though. Maybe I don't know if anybody knows the answer. One of the footnotes. Yeah, footnote 5 was California doesn't have a comment similar to the one the other jurisdictions have on Rule 1.3. Does anybody know why we didn't have that in our rules?
I would just say that from my research on it, that not a lot of jurisdictions have that, but the ABA model rules suggest it, and some jurisdictions have adopted it. But I mean, someone may know whether that was even discussed at the rule revision idea, but it's not too many states have it. There's some examples, and I think we cited to those. There may be more now, but that's, yeah.
Okay, and I was just curious if anybody.
Yeah.
Yeah, I had the same thought, Ken. I thought that was an interesting footnote, and maybe I wonder the same thing. And looking at the executive summary of the rule revision, it didn't shed any light as to why they chose not to include that particular comment, unfortunately.
Let me just mention that the issue of a succession plan as a requirement in the rules of professional conduct was considered by the earlier iteration of the Rules Revision Commission that was chaired by Harry Sondheim, not Justice Lee Edmond. And one of the recommendations that they adopted was to affirmatively not add to the rules a requirement for a lawyer to have a succession plan. The commission at that time, the Harry Sondheim Commission, concluded that the benefit of such a requirement for client and public protection did not, on balance, overcome some of the concerns with having such a rule. And the concerns that they raised was that the succession plan requirement could fall uniquely and disproportionately on solo practitioners and potentially on lawyers of color who are solo practitioners. that it would be unclear because the rules of professional conduct are disciplinary rules, who would be subject to an attorney discipline proceeding if an attorney died without having a succession plan. And they also raised the issue of if the state bar were to inquire into the adequacy of succession plans for solos, then would the partnership agreements or shareholder agreements of multi-lawyer firms be similarly subjected to scrutiny by the state bar to assess their adequacy for protection of clients when any one member of their firm are not able to continue to represent the clients that they're assigned to represent. And they also observe that there are procedures in the state bar under 6180 at SEC that provide protection in the event that an attorney dies or becomes sick and unable to continue in practice. After the commission acted, the state bar did develop the surrogacy agreement that is posted on the state bar website, which is a voluntary document that a lawyer can enter into with another lawyer to provide for coverage in these types of situations. So right now, the bar's approach is more of a permissive one than a disciplinary standard one. And I'm not sure if the rationale from the Harry Sondheim Commission holds up today, but historically, that's where I think the current position comes from. There were some perceived inequities about a rule of discipline on this topic, and also some practical considerations about applying it to solos as well as to other lawyers and the practice forms that they are practicing it.
Yeah, that's helpful, Randy. Thanks. I also wonder too, because of California, just their approach to the rules has been, more discipline based and less aspirational than some of these jurisdictions that, I mean, this is not necessarily a rule that you see associated with discipline issues in these other jurisdictions. Courts, the state bars want them, the judges want, lawyers to consider these issues, but sort of short of imposing discipline if they don't, right? So it's like that tension between those concepts where, but I mean, I would depend on the circumstance, but it seemed like even the language and in the model rule comment, is like they may require them to develop. It's sort of like the comment saying that this is like a best practice or you should consider these things and not actually saying it's required as a rule specifically, right? There's a couple jurisdictions that have them as part of a rule, but not very many. Yeah.
I was intrigued by Randy's comment about what's the form that the state bar has that on, I guess, a temporary one-time or occasional basis, you can bring in another lawyer to cover with some kind of agreement. Did I hear that right?
Yes, if you go to the state bar's website in the ethics information area, I don't know, maybe you can project this just very quickly. There's an area for resources for senior attorneys.
Well, my thought was, rather than have any kind of suggestion for a formal requirement, sitting on your shelf that says in case of disability, break glass or something, just make some reference to that possibility as one way of mitigating foreseeable damage or harm to a client for consideration. And I think that is beyond just a mere best practices discussion, depending upon what this form provides, but also something that might suffice for an unforeseen, until it actually happens, temporary disability, as to what you can do in lieu of having a formal succession plan. And if it exists and if we agree with it, then maybe we ought to advert to it in this opinion.
Well, I don't think are you able to pull that, Mimi? It doesn't look like it's available.
I think it was on the last screen there under surrogacy.
Yeah, but then it doesn't come up.
There's a sample.
There's the closing the practice of law one.
Click on sample agreement. That's the one.
Yeah. Yeah, so that's what we're talking about in the second scenario. That's at least the way I view that. And certainly we could reference this and, as a footnote or whatever, as another resource for people.
Okay.
Okay, well, does anyone else have any other feedback?
Sorry, I got frozen. Can you all hear me now?
Yes.
Okay, so I'm sorry if I missed something here. Sounds like you just talked about including the surrogacy program and related content from this that the state bar already provides as a resource for this
Yeah.
opinion. So I was going to say that. And the other piece I was going to say is, Randall, is it possible, if it exists, there's some kind of written observations by the Rule Revision Commission that you mentioned from Chair Sondheim's group that talks about their concerns with a succession plan?
Yes, I will pull that and have Mimi circulate it. It's from that commission's document, Concepts Considered but Not Recommended for Adoption. It was then Executive Director Judy Johnson who had actually asked the commission to explore whether the rules should require a succession plan. So they did look into it, and it ended up in their Concepts Considered but Not Recommended for Adoption. I'll have that.
And what year was that, Randy?
It was around 2010.
That's great. Thank you, because I think we want to be mindful of what their concerns were as we tailor this opinion.
Sure.
So that would be very helpful information for us. Thank you.
Will do.
This opinion also gave me another idea on the flat fee one, because where it talks on page 5 about safeguarding funds and client property and a client's ability to retrieve the funds. Seems to me that would be far more difficult if they're in an operating account as opposed to a trust account. So it gave me further food for thought on the flat fee advisory. Or opinion, I should say.
Yeah, I guess it depends on who has authorization or access to that, right? Yeah.
I mean, I would assume they're easier to get them from a trust account than an operating account. So.
Any other comments, questions about this opinion?
All right, if you're interested in working on it besides Ken, let me know, or I think it's Ken and Joel and Toby are my subcommittee right now, right? And you, Justin, right? Or you're the advisor?
Yeah.
Yeah.
So let me know what you think is realistic, Dina, but given how close we are to our next meeting, I'm thinking we work on revising this opinion, and then not the next meeting in June, but the following meeting, we'd put it back on for discussion. Does that work? I mean, unless you think 3 weeks from now is realistic, that would be my inclination to wait.
I think what you said sounds good, because I think it's not just 3 weeks from now, it's like minus 10 days of agenda posting and those types of things. So yeah, it's basically a week, which I don't know that they'll get together on that. Yeah.
So
Makes
you'll get
sense.
ready for the July 29th meeting.
Okay.
Great. All right, well, we're moving along here. We're cruising today. So do we have Brandon yet?
Yes.
Oh, great. So if now's a good time, Brandon, we'll turn to 200005.
Yes. I'm just trying to turn up my speakers a little more. 1 second here.
No worries.
That's not going to work. Anyhow, it's been a while since I made these revisions. I think I made them for February. They were supposed to be consistent with everything we had discussed during the previous meeting. And, at that point, the drafting committee, we had some discussions about whether we thought the hypothetical scenarios were even useful, because we were so reluctant to approve any any conversion clause scenarios. And the one scenario that was most likely to be permissible had truly unique factual circumstances. But we've talked it over back and forth with the committee and with leadership. We're still including these scenarios for now. I'm comfortable with the scenarios, but I do want to throw that question to the committee again as to whether they believe the scenarios are useful when we are, the circumstances under which we view conversion clauses as ethically permissible are so narrow. So yeah, there are no dramatic changes. There is wordsmithing, there is some reorganization in the red line, and that's about it. I mean, we talk about the ways in which conversion clauses can impermissibly burden an attorney, a client's right to discharge counsel, can impermissibly burden a client's authority to make settlement decisions, and the scenarios are intended to address some of the ways that in our practice we have seen conversion clauses drafted to work, with the exception of scenario 5, which on the drafting committee, none of us have ever seen a scenario like that, but it was our best attempt to envision a scenario where the conversion clause did not strike us as impermissible. So I'm not sure if we should walk through any, I mean, it's been a really long time since we had any sort of substantive discussion or disagreement about any of the issues. So I'm not really sure how best to present it.
Well,
beyond that.
yeah, no, thanks, Brendan.
Sure.
I think we've gone through these scenarios in many meetings. So I don't, unless there's a particular one you want to go through, I think we've covered that. I do think maybe we can start with the discussion about the scenarios, and I can offer, I'll throw the leadership under the bus here. And we were asked our view about the scenarios, and I think, you know, our view, and Sarah and Dina can correct me if I'm wrong, is, you know, for present purposes and given kind of historically that we do have scenarios in opinions, that it was, at least for initial public comment purposes, helpful to keep them in. Let's see what reaction, what input we get with the sort of current total version of this opinion, and see how that informs both the scenarios that we presently have, whether we would want to modify them, or perhaps even as the inclination or instinct has been some of the committee members to consider removing the scenarios. But since we have them, and since they do provide, I think, a helpful color to these draft opinions as we're working through them, and other reasons, I'm sure as well, our thinking was, okay, let's leave them in and let's see what the public thinks about them, and then recalibrate from there. And so that's kind of, you know, Dina, Sarah, I don't mean to speak for you, so if you have nuances there that you want to throw in, please by all means do so. But that was our thinking at this point, and happy to be talked down from that, but at least for now, that's where we're at.
Yeah, and just my
Yeah.
2 cents. Sorry, I'm totally comfortable with the scenarios and how they are presented here. And my question was just more, are they adding value? And to the extent anyone thinks they do, I'm totally fine with them. There's nothing in the scenarios that I think is problematic personally. So I'm totally comfortable with that approach. And I am anxious to see what the public comment will be to this opinion generally.
Yeah, I think I agree with everything Justin said. I think they're really important for illustration purposes, because if you have someone that's like, what is a conversion clause, right? And they're thinking about it, like even just the hypotheticals themselves tell you an example of what a conversion clause looks like and how you think about that. So they may not associate what they're doing with a quote unquote conversion clause necessarily, but seeing it, the illustration, I think, is super helpful. My only comment with respect to what you have is I don't think that 3 is necessary, because I think 3 and 2 are so similar that you could easily get rid of 3 and not lose the value of the illustrations and examples. That's just my feedback on that, because I think they're very similar. But I do think having them is important. I think, you know, I was thinking about 5. I think it's important because it shows an example of when it could be, even though maybe it seems like you're straining a little bit to get there. And I was trying to think about ways to, you know, to view that scenario. But I feel like you guys inherently felt when we discussed that there was ways in which it could be okay. And we're trying to say, we're not saying it's 100% always wrong. And I mean, I think this is an effort to do that. I think that's an important counterpoint, right, to the opinion. So that's my feedback on the hypos.
I think that's great. There's a one line, right before discussion at line 57, there's a line that was added, which says that when the analysis is performed, the circumstances where a particular conversion clause is not ethically prohibited are rare, which is a pretty dramatic statement. And I think, I agree with that statement. And once we have that in there, I'm totally comfortable doing scenario 5, because it really does have these unusual facts that would make it far outside of the normal ethical concerns I have with conversion clauses. So, and as to removing 2 or 3, it would be number 3 you're thinking might be sort of redundant. Remember, I was trying to give a slight gloss to each, I was trying to tell practitioners, here's another way that you might have imagined you could accomplish this indirectly that we still think is improper. And that was why I had the slight differences between 2 and 3. I'm fine either way, however we want to put this out into the world. Contingency occur.
Oh, you're on mute, Dina.
Sorry, I was just saying, I just wanted to offer that as a point of, consideration, not that others may disagree, and I don't feel super strongly about it, but it was an observation that it felt like it felt a little bit repetitive, of some of the, so.
It is. And Dina, I think you're absolutely right. And I think the only value it has as distinct from number 2 is just what I was saying, that I think in our drafting committee, we've actually seen just so many permutations of how people try to phrase this to make it look like it's something different than a conversion clause. And I was just trying to capture that again. So it might seem a bit redundant, and I'm okay either way, but that was the goal. Scenarios 1 through 4, I've seen all of these many times. So that's just my 2 cents on that.
Yeah, this is Joel. Can I weigh in just for a second? First of all, Justin, thank you for the explanation of leadership's view on the scenarios. Understanding that, I think I could live with them, although I was in the camp of not including them. But if they are going to be included, I would leave in 3 as another permutation. But on 5, in the analysis section, I think we ought to add that something along the lines of, at a minimum, the 2 of the requirements to even get you into the ballpark are informed written consent of the client after independent counsel and sophistication of the client, which are, though they're kind of alluded to, that we don't just say so. And I think it might be a good idea to add that if we're going to send them out to see what the world thinks.
Okay, well, maybe the subcommittee in the next iteration can massage those thoughts, Joel. I think maybe, at least with respect to the sophistication of the client, maybe there's a way to more overtly talk about that in that scenario. And I can't recall if it talks about informed written consent or whether the subcommittee, how the subcommittee feels on that, but seems to me looking at weaving those concepts in if they seem appropriate. And then hopefully for the next iteration here, I mean, tell me if you disagree, Brandon, but I think we're close to public comment on this one.
Yeah, in fact, I appreciate Joel's comments. I have sort of a competing goal, which would be to potentially vote this out as soon as we can, because I know some other ethics committees are looking at this issue. And, I would love for us to get this out there in the world for consideration by them as opposed to vice versa.
Can I raise something then that I noticed in looking at it again this time, and
Yes.
that I have concerns about? It relates to, I think, the discussion in section C on pages, well, I guess it's one sort of on page 3, there's a discussion of quantum merit initially, and I kind of want to go back to that as I talk about section on page 6, but I wondered if we wanted to have a definition and try to explain a little bit more about what quantum merit means and how it's been defined in cases, and because it's just referenced, and I think that it means different things to different people, and obviously it's a reasonable standard, but sort of having a definition is important. And then I also, this relates to, and I made several notes, and I'm just trying to, I'm sorry, I'm going to get you all over the place, Mimi, but on page 7, and it's lines 224 to 230, and some of the paragraphs above that, but that paragraph in particular, when we say a conversion clause which requires the payment of a predetermined contingent fee to a discharged lawyer, and then it's not likely to survive the unconscionability analysis. And then the case cited really talks about an attorney contract requiring the payment of a minimum fee and not a predetermined contingent fee. And I bring that up because when I was reading this, and I was thinking about situations in which, and this happens a lot in departure contexts, but it happens in different contexts where you have joint counsel, where you have an attorney who's, perhaps in the law firm context, and we can think about it with partners, where there's an agreement in a contingency practice that if when this partner leaves, if they go and a client elects to take their matter with them, that the firm is entitled to get, usually there's some related discussion of the quantum merit analysis, but it also often relates to something that's basically is, the firm can get something for sort of its marketing efforts. I can't remember if we talked about this before, but like marketing and, generating the matter based on the firm's resources and efforts to bring that client in when you talk about those types of practices, right? So, and the cases, there's like the talk with I don't know if you're familiar with that Caceres case that talks about the context of fee splitting in this context, where you can actually say it doesn't increase the fees to the client, but you're talking about a situation in which something happens, there's a termination of that relationship, but what is considered quantum merit isn't necessarily like just the work that the attorneys put in. And it really can be based on a contractual agreement between those two attorneys, whether they used to be at a firm together or they were joint counsel on a matter and the client decides to go with one of them. And so I bring that up because I know that's not technically conversion, but I feel like it might be worth in a footnote or something to say, because some of this language I feel like is pretty blanket statements about this, and that's not a conversion clause situation per se, although it's a situation in which the termination of the relationship triggers how the attorneys are ultimately going to be paid. It's not in a way that should impact client choice, but sometimes a client could argue that if the firm said, hey, we get 50% for generating the matter, that's going to make it prohibitive for that client to then go hire another attorney, right? So these are related concepts, but they're different. But I'm concerned about some of that language, I guess I should say, in some of these where it suggests that it always is just strictly quantum merit if we don't really define what quantum merit is.
That's a great point.
And then this paragraph, I just don't think that statement really mirrors what that case says. Because I think that's just a fee as opposed to a predetermined contingent arrangement about how those attorney fees are going to be paid. So,
did you want to include, do you think that that other case that you mentioned should be included then somewhere?
I was wondering if maybe in a footnote, we want to say something like, this isn't intended to address this other type of situation that I'm talking about, in which an analysis, because I think it's important to note that attorneys can agree to, like, it's like a referral fee, like the concept of, we recognize in California ethics that you can, regardless of, sometimes there was language here saying that, you can't, regardless of the amount of work that was performed or remaining in the matter, like they shouldn't get some certain amount. Well, that's not true with referrals. Like, we recognize that, and that attorneys can come to arrangements with each other about how they share those fees. Again, as long as you're not talking about a situation where the client all of a sudden has to pay more because of what's happened with the attorney's relationships. So I do think it would be valuable to distinguish that scenario so that there's not confusion about some of the blanket language and what is a conversion clause,
I think those are great points. That's excellent. And ones I hadn't considered. That's useful.
Well, part of it helped with me, like, trying to analyze like what is a conversion clause? Like anyway, I got myself, but
You
yeah.
know, you're talking more about, let's say, if I was able to understand, you're talking like in a partnership agreement of, you know, a lawyer leaves, how they divvy up clients or fees, or?
That's one way in which it can come up, but it also comes up when you have joint retention, when you have co-counsel relationships, and then sometimes those relationships split up because those attorneys don't want to work together, or they can't work together, and the attorneys have agreed as to how they're going to share the fee for the client. The client wants to make a different arrangement in the middle, so it's not always, you know, so it's just the idea that those attorneys can agree to certain things, and they can value certain things in terms of how that contingency fee is shared in a way that doesn't increase the cost to the client. That's the point of those cases. But it's not saying that just because, you know, attorney A worked on it for 20% of the time and attorney B worked on it for 80% of the time, that attorney B gets 80%, attorney A gets 20%, that there could be a different calculation based on their agreement, who generated the matter, referrals, like a bunch of other considerations that are permissible. And that case says that it's a California case, as long as we look at the idea that it's not going to increase the cost of the client. So I think it would be helpful to distinguish those cases. And I can send you that case, Brandon, or put together a sentence or a couple sentences that you could consider.
That'd be great. Thank you. Thank you.
Yeah,
That's great.
Justin, on a related topic, I just got in a new matter 2 days ago, and there's a case I got a head note on, which I haven't read yet, but it suggested that when attorney two, well, in this case, attorney two insisted on a full 40% contingent fee, taking over the case literally a month before it settled. And the case that I found, which I haven't had a chance to read yet, seemed to suggest that attorney two's failure to explain that the 40% was in addition to attorney one's quantum merit claim is a violation of 6147, because it did not explain how the 40% was calculated. And I'm going to go read that maybe over the lunch hour, but certainly by tomorrow, and get it to you.
Is that a
That's
new
excellent.
case, Joel, or
What?
is that a new case you're talking about? So 61
No, I can't remember. I wasn't even thinking about it until just now.
Okay,
I'll go see if I can find it and get it to you guys.
all right.
I also have some comments, but Dina, I wasn't sure if you were still going over yours. You're on mute, Dina.
Go ahead, Sarah.
Thank you. So just first, I do think the hypos are very helpful and add value. I found them all useful, and I agree that I've seen several of them through my practice. I think they're very useful. But the one thing that I guess I might have misread the first time, and I'm just a language issue I think it's in the digest and on page 2 where you say if you could just go up to the digest, it's just the language not ethically prohibited. Maybe that could be reworded to say ethically permissible. So we're not saying not prohibited. I don't know. To me, maybe it's just me. I found that confusing when I read it. And it's not there, but maybe it's not the digest. If you could scroll down, I'm
I
not
think
sure.
you're talking about on line 57, 58, the new sentence.
It's at the very beginning of the digest too.
Yeah,
First
yeah,
clause.
right there.
So Sarah, that's a great point. I had some reason for doing it this way, and whatever it was not persuasive enough to remain in my brain. Do we like the idea of saying this is ethically permissible? Is that just a better way for us to talk? Because I know I do what Sarah's referring to. I do a lot of times in the opinion. I can switch that. How do we? I mean, is it better just to say, under these circumstances, it's ethically permissible rather than saying not prohibited?
I'm fine, yeah, that's fine with me. If we're saying the particular clause rare where the particular clause is ethically permissible.
It's just clearer for
Sure.
me, at least, when I see it that way. I think I,
Okay.
That's fine.
um,
Yeah.
and then
Was
there
there
were
somewhere else that had that, or?
yeah, I think on the,
Wait,
Kyla
wait,
pointed
wait,
out,
wait,
maybe
wait.
it's the first, it's
Before
on the
we get to
beginning of
the
digest.
is ethically permissible, can we maybe instead use use may be?
It was actually the first line of the digest. Oh, but you're back here. Let's see.
I think Joel wants to change this to maybe instead of is.
Okay.
Is everyone okay with that? Well, here, but it's also appears not ethically per se, but whether a conversion clause. Then would we make this maybe also?
I feel better.
I was okay with is, but I'm flexible.
Yeah, in that situation, it seems like is
Is,
correct because you're saying whether a clause is permissible must be evaluated. I don't think
I
you
agree.
would say whether a clause may be permissible. I mean, I guess you could, but.
And I'm happy to go through the whole opinion for where my language was appropriate or where it's needlessly confusing in this formulation.
let me just
Okay.
It's there,
highlight it here
yeah.
just in case for you to consider then.
I think right there on line 13,
It was line 11 that I,
Yeah,
I
line
thought-
11 is not.
it says not, the clauses, conversion clauses are not ethically prohibited per se, but require, it's rare where conversion clause is ethically permissible, I think would fit.
Like that.
Yeah.
I keep on spelling it wrong. Permissible. Just highlight that for you so you know that that's what changed.
my other comments related to some of the red lines on page 3. Yeah, right there, around line 95. I just question that whether that's an maybe overbroad conclusion that a conversion clause which entitles a lawyer to more than a quantum merit fee or how much work has been performed or remains to be performed is likely to make it impossible for the client to secure replacement counsel, thus impermissibly burdening the client's right to discharge counsel. I'd feel more comfortable saying something like significantly more than a quantum merit fee, or I just question if in all circumstances, just the mere fact that it entitles a lawyer to more than a quantum merit would mean it's not permissible.
Where would you get more than a quantum merit though? I guess that's the question I would have.
I think it depends on a lot of, I think there are a lot of facts that might go into the negotiation of the initial agreement and the conversion clause. And, if it's the client, and your last typo goes into this a little bit, but, if it's a client who's really insisting on having a contingent fee agreement, but there might be, and it's really, the lawyer doesn't want the contingent fee agreement, but agrees to do it, but it's undertaking a big risk. I think there are a lot of factors that go into whether a fee is reasonable or conscionable or unconscionable. And I think there could be facts where.
Well, but Sarah, the risk factors that each attorney undertakes are included in the reasonable value analysis, and how significant a contribution is by either attorney is included in the reasonable value comparison and analysis. So adding significantly suggests that you get some kind of bonus above the fair value of the work you put in, which I don't think is what we ought to be saying. I don't think it's permissible to give you some kind of bonus other than that which you've earned.
Sarah,
Yeah, but an
I-
hourly rate that isn't significantly more than that wouldn't be a bonus. It would be some value or some metric, right? I mean, yeah.
I approached my starting point on this opinion was exactly what Sarah was suggesting, which was that where a conversion clause results in something, significantly or materially more than quantum merit, that's going to be prohibited. But Joel and Ken just asked me to, what are the circumstances in which the first contingent counsel should be entitled to more than quantum merit? How could that ever be? And I was a bit stumped by that. And, the only circumstances I could come up with were sort of number 5, which are really rare. But it is part of the opinion. So I think Sarah's point here, I was thinking, maybe there's a different modification to the phrase that concerns Sarah, which doesn't talk about it being significantly more than quantum merit, where it just says that where it is more than quantum merit, it's going to require this careful scrutiny to make sure that it's not burdening these client rights. I'm not sure, but this has been sort of a dilemma that we've been wrestling with a little bit in the drafting.
Yeah, and I don't know, I'm trying to imagine factors where it's, you really want this particular attorney whose schedule is super busy and the attorney really doesn't want to take on the matter. And the attorney is going to add a lot of value given the reputation and experience and expertise in a particular area. And it's a negotiated agreement where the client's the one wanting the contingency fee agreement, but the attorney wants to ensure that in the event, in the future, that if there is this conversion clause, I can imagine situations where it's just negotiated, the client clearly is informed of it and agrees to it, and it's still reasonable, even though it's more than quantum merit.
Well, no, quantum merit and reasonable are synonymous. And if you haul out the arbitration advisory on calculating a reasonable value, everything you've just suggested is included in the factors which go into that analysis. The time, availability of the attorney, the reputation of the attorney, the skill of the attorney, the previous experience of the attorney, and what that does to the value of the case, including all of that piled up, may get the settlement that the first attorney couldn't get. All those things go into the reasonable value calculation. And to suggest otherwise, I think is just not right.
Well, that's why I think it should be defined, like I said, my earlier comment, because I think if that's what you're saying, I mean, I don't think you and Sarah are really saying anything very different, but I think it's not clear what, I think sometimes people think of quantum merit, and I've heard people make this argument that it's this exact percentage proportion to, breaking up the work performed in point A versus like this 80-20, this and that. I think that we should define it so that when we're saying it's reasonable and it could depend on a variety of factors is really important to this, to making such an absolute statement like this.
Well,
I think
because people have a misconception of what reasonable value means and want to use a straight hourly formula, that's wrong. And so to make up for that misconception by inserting that there's something significant other than the regular normal quantum merit reasonable value analysis makes this misleading.
Well, I think
compounds that misconception, in my view.
I think
Right.
there's another gloss that makes it a little more complicated. If you look at the recent Pesh decision, which talks about, that was an hourly fee case, right? And there was a dispute over the reasonableness of the fees. And but the contract, the hourly fee contract, was found to be valid. So then the court says, if that's the case, I'm not going to disturb the hourly rate, even if it is higher than the hourly rate I would have come up with for quantum merit. And I'm just going to assess the reasonableness of the hours and tasks performed, right? And that is going to come up with a higher dollar amount for the fee than a straight quantum merit analysis. And I wonder if there are attorneys that would say, I'm not going to take your case on a straight contingency. What if you bail 2 years into this case and I've done all this? I'm not going to do it. I need some protection, and the protection I demand should pay my hourly rate. Is that something the two parties can contract to which would likely result in something. I mean, for example, there are people that do that where there's no contingency. The contingency doesn't even have to occur for me to get my hourly rate. And are there circumstances under which that could be appropriate? The Pesh case has me more timid about some of the bold approach I was taking earlier.
But what your percentage, what justifies your percentage in a contingency case is taking the risk. And that goes into the unconscionability argument. In other words, if there's a huge risk, you can have a much higher contingent fee percentage than if there is no significant risk, in which case a 30% contingency might be unconscionable but that's just not the same as a straight hourly contract where you're not taking on the contingent risk. And
Right.
so you've hedged your fee by saying it's hourly, it's by a contract, stick by the contract. I think that's all the Pesh case says. I don't think it applies to comparing two lawyers who agree to take on the contingent risk in some fashion. And then their job later is to duke it out exactly what risk they took and what value they gave to the resulting achievement of the contingent event.
I think you're absolutely right. I think what I was thinking of, and I'm not sure it's exactly what Sarah's thinking of, is circumstances where the attorney just doesn't want to do it on a contingency and the clients start begging and coming up with creative ideas. That happens. I mean, that's happened to me many times. And it's challenging because you want to provide legal services for people that need them. But I had a client once come to me who was facing criminal investigation, but had a malpractice claim. And I said, if you get indicted, you're going to have to walk away from this malpractice. And he wanted me to take it on a contingency. And he said, well, I need to save my cash for my criminal defense, but I'll make a deal with you that if I get indicted, then I owe you straight out. He was pitching all these ideas to me and he was very sophisticated and I wasn't comfortable with any of it, but I've always felt badly that this guy couldn't get counsel, right? Or at least me. I'm sure he got someone else. But so there are challenges there, and it is not crystal clear to me that it's that you can never deviate at all from quantum meruit. I'd be very comfortable saying that any deviation from quantum meruit, it requires heightened scrutiny to make sure it's not impermissibly burdening these rights that we've been talking about. But I can understand the feeling that it's too strong and unyielding if we just say you can never deviate from quantum meruit at all.
So just because I want to make sure we get through this before lunch, let me just distill what I think we're trying to do. And I think that the subcommittee should go back and try to work on these, at least as I'm distilling it, two concepts. One is somewhere, whether it's here or elsewhere, we should define quantum meruit so that the reader has an appreciation for what that actually means, consistent with what Dina said. And two, in this paragraph, starting at line 94, to somehow create some nuance or watering down of what I think Sarah described as sort of a somewhat overbroad conclusion, so that it better accounts for the fact that, you might, in certain instances, have a scenario number 5 crop up. So some of the maybe absolutist, overbroad nature of the statement as presently written could be watered down to account for the scenario 5 type of situation, that unique circumstance where maybe it isn't, that the general rule wouldn't apply. And so if the subcommittee could go back and work on those two concepts, I think that will maybe move the ball forward on this issue.
Sure.
So that's my way of saying maybe we could move to another part of the opinion, so we can wrap this opinion up before lunch. And then, the good news for, I'm sensitive to your concern, Brandon, of wanting to get this out for public comment. I think the good news is we have another meeting in 3 weeks. So if the
Yeah.
subcommittee is able to put in the, burn the midnight oil a little bit, I think we can get this in closer shape, and maybe we'll be in a position to get it out for public comment soon.
No problem. We will definitely do it.
So, Sarah, I didn't mean to cut you off if you had other areas.
Yeah, I
of
just
your
have
opinion.
one other comment, and this discussion was helpful. Brandon, if you could forward me that case you referenced, the Hesh case.
Oh, it's PECH,
Or-
P-E-C-H-E. I will do so.
Yeah, that'd be great. Okay, so my other,
It was in my materials for the ethics symposium, or our
Okay.
materials. So.
sorry, I missed it then. The other comment I had is on page 7, at least of what I was looking at previously, around line 210. Let's see.
Yeah, sorry, things might have shifted since I started taking notes.
Wait, could you go up? I think it's higher up on the page, so I think it's around line 210, or maybe here. Yeah, it's line 214 on this one. Okay. Yeah, that redlined addition, it's the view of the committee that a conversion clause which reports to entitled discharge attorney to more than quantum merit is ethically prohibited. So my same comment would apply here, that I made above, but second, I had a question about the second part of this, which is,
Then you can talk. Now you can talk.
So how do you talk?
You just talk to him. There's a microphone there.
Let's turn it
Uh,
off.
Hear you guys in LA.
okay, so as is a conversion clause that would report to entitle the attorney to any fee where the attorney has lost faith in the matter and quit and or otherwise abandoned the client. So I might be misinterpreting this second conclusion, but I'm reading it to say that if the attorney quits, they're not entitled to any fee. And I don't know if that was the intent.
That's the case law, yeah.
Yeah, if the attorney quits for, their own reasons because they've lost faith in the matter, the case law says they don't get a fee. If there's, if they're fired or if there's some other, it's a factually specific analysis, but the Russ Miliband case line of cases, if you, just say, I don't believe in your case, you're going to lose, I'm out, you're done for your fee.
Yeah, but I think it might be clarifying, the language lost faith in the matter and quit is somewhat ambiguous. There might be reasons that they lost faith and quit, but it was permissible to end the representation within the meaning of the rules. The client might have engaged in conduct that made it unreasonably difficult to carry out the representation. There might be situations where the lawyer quits as ethically permissible under the rules. And I don't think in that situation, I don't know, maybe I'm familiar enough with the case law, but that they would necessarily not be entitled to any fee in that type of situation. I agree where, if you quit without any good cause and.
Sarah, that's exactly the Russ Miliband case that Brandon mentioned. And in that case, the attorneys decided they didn't want to be in the case, and they stopped answering questions that the client kept asking. And the conclusion was that the client repetitively asking all these questions was an undue burden on their ability to handle the case for the client. And the court disagreed. And the court said, no, that's your job, is to answer those questions. And so that was a pretextual withdrawal, which was an abandonment. And they were really
I'm not disputing that type of situation, Joel. That's not the situation I had in mind. I was thinking of a situation where the client is refusing to provide relevant information. I'm not talking about where the attorney is refusing to communicate and abandoning their client. I'm talking about
My sentence is totally ambiguous. Sarah's right.
Yeah.
I knew what I was talking about, but it's not at all clear. So Sarah's correct.
Yeah, I had the same concern, Sarah, and I'm familiar with that case. I think that it needs to be clarified with a citation to the case. And if you're going to quote language from that case, because otherwise I think you need to reference that they would be entitled to a lien or something. We don't want to say they're
Right.
entitled to nothing. And I think it needs to be clarified too. Thanks.
And I don't know where I do it, but I do. There's a footnote and a little bit of conversation about the Russ Miliband cases elsewhere.
Yeah.
But that doesn't mean I should have a sentence as unclear as this one. And I'll refine that for sure.
Yeah.
Okay.
I don't want to beat a dead horse, but I also laser focused onto this language too, and it was going to be the comment I made. And the hypothetical I drew in my own head was, what if an attorney was just doing a bang up job, A+, winning every motions, building credibility, increasing the value of the case by just being just a savant. And then all of a sudden it turns out, the client lied about some key fact, and the lawyer just loses faith in his or her client and leaves the case, but now it's worth much more because of what a bang up job this lawyer did. Is that lawyer out of luck under the Russ Miliband line of thinking? I don't have the answer, but it certainly made me question the statement here under that scenario. So yeah, and as a general matter, I think as you're going through this as a subcommittee, Brandon, I saw, Sarah pointed out the prior line 94 that we talked about, and then the paragraphs that we're talking about here. I think there are places in the opinion where there are these types of, I think, absolutist type statements, for lack of a better description, that I think we need to look at more carefully and either water them down or recognize that there can be some nuance. That scenario 5 might exist. And so we might need to recraft the language to acknowledge that and use, more caveated language in places. So as you're going through that, that's my general comment, to keep that in mind where we might need to soften the language or adjust it in some way.
Justin, I'll have to try and dig out the case, but there is a case I know that has that exact factual scenario which you just laid out, and the attorney then sued the client for fraud for failing to disclose this horrible fact that ruined the case. And the court said, no case. The attorney took that risk when they took on the contingent fee case, and they're out of luck. That's just that's the way the game is played. That's part of the risk, which justifies the high recovery. So
send me the case, because I want to understand these issues. If you can find it, and I think as a subcommittee, you should definitely talk about whatever case that is and see how it informs the analysis. But I'd also like to see that case.
Yeah.
Personally, I'm trying to understand, some of the definitive conclusions in this opinion, because in my own mind I always go to the scenario 5 because it makes me think there are going to be situations where conversion clauses are appropriate, and that as much as we're trying to be client protective here, there are situations about fairness to the lawyer that come up. And so if cases have said, sorry lawyer, you're out of luck, not about fairness to you, like the case that you just mentioned, I want to understand the facts of that case specifically. So please do circulate that to leadership in the subcommittee if you can find it. It sounds like it would be important to consider in finalizing this opinion.
Okay.
Anything else?
I went over all of the comments I had, so thank you. I think this was helpful, and I struggled with scenario 3 a little bit, but I think I ultimately agree with the conclusion. I was going back and forth when I was reviewing this, and that might be an area just to think about as you go through it again. But I think I overall agree with it. It just, I'm not sure if there's particular case law in that particular scenario or not, but
Any other questions or comments?
Yeah, just on one last thing, just on that scenario 3 too. I think, Sarah, the reason I agree with you that I had some hesitation or concerns about that too, in terms of the conclusion about it. I think that I think that was one of the reasons why I said let's just remove it. when I said like it was similar to 2, but then it also wasn't. Brandon, I know you crafted these like to be slightly different, but then I think it was because I was like a little less comfortable with that, because I think in some places people could have a contingency fee agreement where they, even if that they are able to craft something that they get some recovery, it wouldn't be beyond quantum merit, but it would be reasonable if there's not success. And I think that's okay as long as it's not, you know, this premium. And I think so yeah, I want to think about that more too. But I think the way you've described the analysis, I would probably agree with your conclusions, but the scenario in itself is like not a clear answer to that, right? So
Right.
yeah.
All right, well, what I'm thinking in the spirit of trying to be efficient today and allow folks to leave early to get back home from driving is why don't we take our lunch break now, come back 15 minutes early at 12:45, start up 15 minutes early and you know, hopefully end a little bit earlier as well. Is that okay with everybody? Come back at 12:45?
Yes. Thanks.
Brandon, I have a question. So do you think you're going to have this opinion redrafted for the June 3rd meeting?
Yes.
Just so you know, anybody who's preparing redrafts for the June meeting or a draft for the June meeting, the deadline to submit materials is going to be 10 days from today. So it'll be May 23rd.
We will do our very best. Thank you.
Okay.
Appreciate the
All right.
reminder.
All right, well, we'll see everybody 12:45.
All right. And we're back.
Okay, great. Hope everybody had a nice lunch. We're gonna move on to 19-004. I think, tell me if I'm wrong, Hunter, are you currently the lead on this opinion, or is someone else?
He is, Justin, but he's sharing a room with Toby, and they're going to have some reverb problems with the sound. So he asked for me to take the lead on it.
Yeah, sure.
If that's okay.
Yeah, please.
I guess that wasn't sent with the comments, the public comments. Okay. So I don't even really know when we last looked at this opinion, but just as a recap of this opinion, this is back from the first round of public comment, the 90-day public comment period. We got a lot of public comment, and they were in, I guess, other materials that we got. So hopefully you guys had a chance to look at those before. The subcommittee, Ken and Brandon and I took a long look at all of the comments. We got a lot of different helpful public comments and made revisions to the opinion, which is the red line that you're seeing here. We went through the public comments in great detail. And then also when I was doing my session for the symposium on this particular topic, really kind of dug into it a lot in addition. So I felt like we really kind of were able to look at all those comments and what we've drafted and just really fine tune it. And this is the draft that you have. So I'm just trying to think of significant issues that we sort of addressed here, if you want me to sort of go over those in more detail. I mean, like there were some minor things, like how we referred to sort of closed our former client. We wanted to make it clear that sometimes we're not talking about necessarily a former client, that like retention duties could be related to a current client when they have a matter that's been closed and things like that. So we cleared up some of that language. We cleared it up related to matters, some minor things like that. The discussion, I think, I think it's still footnote 7 on attorney work product. We made some changes to that to reflect our review of those ethics opinions and to sort of just simplify that discussion, which is really kind of an auxiliary issue. I think it's still footnote 7, yeah. And we've gotten several comments from various bar associations and other organizations related to that. If you scroll up a little bit, Mimi, from there, we also just made it clear that we're not really talking about the attorney work product that's, wait, no, scroll down, just like, yeah, that little bullet point at the bottom. That, you know, reasonably necessary to the representation. Again, we really made an effort to key off of the rules 1.16 specifically in those various iterations. So it's not whether it's communicated or not, it's about whether it's reasonably necessary to the representation, which tracks the rules. So there's a lot more tracking of the particular language in 1.16D and E in the opinion. And so that was a sort of a major not major, but that footnote 7, as you scroll down, was a better, I think, presentation of that particular issue. It's really dependent on those rules, and we took out some of the opinions that were sort of off topic. That bar association one's a helpful one, so we cleaned up that a little bit. And then, you know, if you want to go to page 7, at the top of page 7, you see some revisions there, just sort of relating to, you know, the idea of intrinsically valuable, other file content materials. There's some changes there. And we added this footnote 11. And this concept of like, what is the life of the client? And that may be shorter than the life of the attorney. There were some people that offered feedback about that. We included a little comment about succession planning here. And so, you know, we just said that basically lawyers should consider the duties in light of the idea that they might, you know, outlive their clients. And so that's just a concept related to file retention that we thought was important and was mentioned in some of the comments. And then I think finally, just like in terms of our conclusion, we just revised those a little bit more to track better with like the analysis on things. Oh yeah, one other final thing I just wanted to, was on lines 323. We just added, which was a suggestion from somebody, just to sort of include some of those lists of items to consider when you're considering whether or not, because we know it's fact specific in many ways, a particular file or document, excuse me, in a file should be retained. These are some factors to consider, whether it'd be permitted, you know, it would be permitted to destroy it depending on if there was authorization. So we thought that was helpful, and we included that like sort of non-exhaustive list of things to consider. I think, and then again, then the final sort of analysis of facts is probably the revisions we did, which are on page 12, is just sort of consistent with what, just tightening up the opinion and making it more clear and mirroring sort of the language that we use throughout in terms of tracking 1.16. So. And then, yeah, so I think there was some comment that, a point that was made, I guess, let's see. Yeah, this is a good point. Sorry, Hunter just messaged me and he said that we should change, and this is a Randy comment, which I appreciate. Yeah, we said in the first sentence in footnote 11, if you can go to that, Mimi, that in some instances, the life of the client may be shorter than the life of the lawyer. We meant to say longer. So that needs to be revised there. Thanks for catching that. That's the opposite of what we intended to convey. Yeah. So those are the changes. And if anyone has any comments on those, we're happy to discuss them. And then hopefully when we resolve those comments, we could be in a position to vote it out for another round of public comment. You know, that would be the idea, since we made significant revisions in line with the feedback.
Thank you, Nina. That's a very helpful summary of the changes, and I thought all the changes were helpful and in line with addressing the public comment we got. I think it's really looking good, and frankly a lot more understandable as the iterations have gone by.
Wait,
Does anybody have any specific comments?
Justin, yeah, just on that last point, I just read the last sentence of your added footnote 11. And it wasn't clear to me at first what the last "they" refers to. because of the failure to properly plan, the lawyer should consider that their file retention duties in light of the notion that the lawyers, their duties, what?
Yeah, it's the lawyers. I mean, it's using gender neutral language, but yeah, we can say the lawyer.
But then that would be inconsistent with the first sentence. That's why I thought it might mean their duties might outlive their clients. I don't know.
What's inconsistent with the first sentence?
Well, the first sentence says that the life of the client may be longer than the life of the law firm. And then the last sentence says that the lawyer may outlive the client, which is.
Yeah, so it's the client may outlive the lawyer. Yeah.
So maybe the last sentence could just be that the lawyer may or may not outlive their client. So it doesn't seem so.
Yeah, that's fine too. Yeah.
Creepy.
So
Yeah, lawyer may or may not outlive the client. And if they do, then consideration should be given to the duties that might continue, such as the duties with respect to the file.
Yeah. Okay. That's all I had.
Since we're on that sentence, any thoughts if you prefer a word other than different than notion, like possibility or something like that? If people like notion, I'm fine with that too.
No, I'm no tied to the language. Possibility is fine too.
Other comments or thoughts either on footnote 11 or any other aspect of this?
Would it be unconscionable to include a clause in the fee agreement that the client promises not to outlive the lawyer? Just kidding. As long as we're being macabre.
Have to give that one some thought. Anything else? I just wanted to raise a question or comment on the first page, the issues in the digest. Maybe we start with the issues. It looked like there might have been an inadvertent deletion. We say destruction of closed civil and criminal matters. I think we want to say destruction of client files in closed civil and criminal matters.
Yeah, I agree. I feel like there were some changes made to that issues too, and they're not reflected in this red line, but I may be wrong. I don't know.
Yeah. I think there might be just maybe something didn't translate. It also, related to that.
It should be in, sorry, Justin, closed files in closed civil. You put an in after files, Mimi.
Right.
Yeah.
In the digest, and now with this headed, we talk about client files. And then in the issues section, the very first sentence, we just talk about files. I guess I'm wondering, do we mean in that very first sentence in the issues, do we mean client files as opposed to just files in general? Do we want to be, is it helpful to the reader to be more precise and say client files there as well? Or do we mean something broader than?
Actually, previously it did say client files. I don't know how or why, but this is what it originally said. I'll show you. In the version that was circulated for public comment, it said that.
Okay, so one of the things I think that came up, it related to that was this idea that we talked about prosecutorial duties, and the prosecutorial duties don't necessarily relate to client files because they're not clients. And so that was a comment that was raised, which is maybe why in the first sentence we took it out with respect to retention of files, and because that was based on that public comment. But then I also recognize now that in taking that out, it's less clear.
Yeah, I mean, it creates some ambiguity with civil, right? But I guess kind of big picture, as we have it right now, what I'm thinking is we want to find a consistent way of doing it. So if we're going to say just files in the first sentence of issues, probably with the edit that we just made to issues where it says client files in closed civil and criminal matters, we probably, to be consistent, want to just say files, because when I read this, I was thinking, well, is there a difference? You know, it kind of created an ambiguity when we just have files here and client files there. And then if you look in the digest, in the second paragraph, we're again talking about closed criminal matters. So to your point, Dina, about, you know, maybe needing to not say client file in the criminal context because a prosecutorial duty might be broader. But we actually use client file in that second paragraph, first sentence of the digest, in reference to closed criminal matters. So it seems like we've got to look more closely at how we're using client file versus file, kind of globally throughout the opinion, to make sure we're addressing those public comments that you mentioned, and while also not creating ambiguity.
Can we just add a
Justin?
sentence at the end of the issues, a third sentence? And what are the ethical obligations of a prosecutor? So we differentiate between a client file.
Wait, Ken, if I can interrupt, backing up to Justin's point, would substituting matter files be an accurate and acceptable way of including the concept without stumbling over a client versus a matter? Or just plain files, leaving it open to the interpretation that might be any old files, like your file you keep for whatever, but matter files seems to me might be a way of doing it.
I have a non-answer answer to you, Joel, and it's maybe, but then that'll beg the question, well, what's a matter file as opposed to a client file? And so that, I mean, my overarching point, I think, is this is already a somewhat vague construct. What is the client file that people debate and dispute, and what is its scope? So I think we just want to be hypersensitive to how we're using these terms throughout this opinion. And so if we were to use, say, something like matter file, just sticking with that for a moment, I think we need to make sure that any type of term like that we would ultimately define for the reader, because it's not one that, you know, is traditionally, I think.
But Justin, isn't matter a term that's specifically defined in the rules of professional conduct now? I can't remember, but I don't think it's that open to.
Well, if it is, then we would want to cite to the definition of matter, put the little asterisk, and then be clear that we're talking about that definition. So as an example to address what you're saying. But I think being definitionally precise is where I don't know that we're going to resolve it, you know, today, but I think that's something that caught my eye.
I just checked, matter is not a specially defined term. But that's why I was thinking, you know, and when the chain, when we originally, one of the comments, if I remember correctly, was we talked about cases, and then that's why we switched to matters, because there could be some transactional things that wasn't really a case as opposed to a matter. But I think, you know, if we want to differentiate that issue regarding prosecutors, we just add a third sentence that says, you know, what are the ethical obligations of a prosecutor with respect to a closed criminal matter?
Yeah, that might be the way to solve it. Is having that, because I do think it should be client files, and I that might be, and then we would just need to make sure that that section on prosecutorial duties is like, doesn't refer to them as client files, and that's probably easy enough.
Yeah.
Yeah, because it really is very different than the lawyer representing a defendant in a criminal case. Yeah.
So what am I doing?
Adding a third sentence under issues.
Okay.
What are the ethical obligations of a prosecutor with respect to a closed criminal matter?
Then would we be
Well, I guess maybe we're missing something in there. What are the ethical obligations with respect to a file or discovery? documents. Because that new statute talks about discovery materials or something to that effect. I don't know if Hunter could chime in on that. He was kind of the expert on the new part.
Yeah, I think he agrees with that. He's on a chat. I just asked him, but yeah.
Yeah, and
I mean, I guess what you're suggesting, Justin, is we just consider it and maybe put it over to the June meeting and vote it out then.
yeah, I'm because yes, I think that this deserves some more thought, and we're gonna have to go through this because just as we're talking, I'm going through the opinion. I'm seeing some of these references to
Yeah, I was trying to just.
client file it. So we got to make sure that that's buttoned up. But just I like what Ken is trying to do here. But I would just play devil's advocate. If somebody who doesn't know anything about criminal files reads our issues right now, my concern is that
Yeah.
too specific that when they see the phrase discovery document, they're not going to know, wait, discovery document in a criminal case, what are we talking about here? And so I guess what I'm saying is, should we be even higher level in the issue so we don't have to worry about all these nuances, file, client file, this, that, and describe the issue more generically. And then our digest, which is much more detailed, maybe that's the place where we break it down a little bit so that when the reader picks up our opinion, they're not already having questions in their mind about what are these terms that are being used in the description of this opinion, but rather it's something that they will already understand and internalize. And then they get into the more of the nuances in the digest in the opinion. So I think structurally, that's kind of what's going on and what I'm thinking about.
Would it clean it up if we say with respect to the prosecutor's file and then take out the discovery part?
For me, that helps.
That's
Go ahead.
better.
Yeah. Yeah, I'd rather be more high level about how we're describing it so it doesn't create questions. So I think that type of edit is helpful.
Yeah, I mean, the other concern is just that, I mean, I have to read that section again, but I feel like we're in that section, we were just really talking about, the new penal code statute and not really like, this isn't an opinion in general about like prosecutorial duties. And I don't maybe want to suggest that it is. So I think if we had a third issue, it should be very narrowly defined if it was part of our issues, because it's not really all about that. I don't know that we didn't look at it from the perspective of we're going to exhaust the topic on prosecutorial duties with respect to files, right? I mean, but maybe we have, I don't know, but.
We could add the code site in that sentence. What are the ethical obligations of a prosecutor with respect to a file and a closed criminal matter pursuant to, and then cite the section? It's getting to be a lot for an issues thing, but that kind of clears it up.
Ken, why don't you and Hunter and I talk about it? Because I know Hunter has some thoughts too, especially since this is sort of in his, he has experience specifically with this. That maybe we should, I mean, as much as I really would like to vote this out today, I think we should think about that. I don't think it's going to be like any major change or anything. It's just like some tweaking and then consistency, like you said, Justin. Yeah.
I'll just offer this because I like our issues that are just one sentence personally, and it doesn't have to be that. So take that for what it is. But I do wonder if there's a way to, and I'm just talking out loud, this would have to be wordsmith by the subcommittee, but if the issue could be something just as generic as, what are the ethical obligations of lawyers, with respect to retention and destruction of files in closed civil and criminal matters, something. So it's just one sentence, super high level, and then we get into the nuance. So just a thought. You don't have to agree with that, but I'm just trying to provide an example of how we could synthesize the issues in a way that's super concise and doesn't create any ambiguity about definitions and things like that. So that's just a one suggestion to think about as you wordsmith the issue section.
Yeah, I like that. I never really liked the two different questions anyway, but yeah, I think that's a good thing to think about for sure.
Other thoughts and questions about the opinion folks have? Okay, well, let me offer a couple more. And these are nitpicky because I think we're super close here, so forgive me. But what was red line 359? Yeah, well, it's now 365, so you're all good right there. I don't know why the word throwing has always stood out to me. What about discarding? Does if y'all like throwing better, that's fine. But I don't know why that's just stood out to me. I'm sorry. I know I'm nitpicking.
How about dumping?
I'm just trying to avoid, I appreciate the connotation that we're trying to conjure here. But I just like in a formal ethics opinion of the state bar, the word discarding.
How about chucking across the room? No.
Discarding's fine with me. I mean,
Perfectly fine with me as well.
Okay, sorry. Thank you for
I
indulging.
don't think any of us drafted that language in the first place, but it's perfectly fine.
All right. All right. There were a couple places, we don't have to go through it specifically, but when you're finalizing this, if you wouldn't mind doing an edit, fine for the word there, THEIR. I think we found one of them already in our discussion, but there are times where we're talking about the singular lawyer and then we talk about there. So if you wouldn't mind just doing a check for that as your.
In what context?
The problem is, even if it is a singular lawyer, you're not allowed to say he or she anymore.
Yeah, we use the generic gender neutral term, so that's why we're there.
I understand, but there are different. So okay, let's go to an example.
Okay.
Line 397. What was line 397? It's probably gone to
Somewhere around here.
Can you scroll up? Oh wait, yeah, I think you're good. You're good. Yes. Okay. So because lawyer B may not contain in any of their closed criminal files. So right, we're talking about just lawyer B, but it's plural there. So I mean, there are different ways we could go about this. One is we could say information contained in any of lawyer B's closed criminal files. So that's one way to deal with it. Or we could say in any of lawyer B's closed criminal files. And so instead of there, you could say lawyer B's. Or we could just say something like contained in closed criminal files and take out that whole phrase there.
I personally think that these opinions should be using there, they, them, that we should be gender neutral and we can use pronouns. I like that we can now use pronouns.
And that's consistent with the courts have recently started to do they, them, their.
For singular?
Yeah,
it's just gender neutral.
Gender
I only
neutral.
know this because I work for CEB and we have changed every instance of his or her, he or she to they.
Right. Well, my English minor is.
I know it's hard.
Yeah, well, people would take it out when I'd write it, and I'm like, no, I'm trying to be gender neutral. Like it's now in the academic world as well. It's becoming more the place to. So.
It's weird times.
Okay, well, I've expressed my view, so it is what it is. I will not lose sleep over.
I just want you to know it's intentional. It's not a mistake. And that's the reason it's that way. So as a committee, I think you guys probably want to decide how you want to address these opinions going forward. That's what the courts recommend. That's sort of the academic world. That's what's considered to be the most inclusive way to use pronouns.
I like it.
Yeah, I think we should continue to use them as if, not try to wordsmith them out because it just makes us more used to using them in a gender neutral way. The more people read it, the more it just becomes more normalized.
I was just doing a Google search on this, and this pops up. Using the plural pronoun to refer to a single person of unspecified gender is an old and honorable pattern in English, not a newfangled bit of degeneracy or politically correct plot to avoid sexism. There you go.
If the internet says it, then it must be true.
That, and it's also the state bar style guideway now. So
Well, if the state bar has said this is how they want it, then that's what we'll do.
yeah.
All right, any other comments or questions about this opinion? So, you know, the changes that we're talking about are fairly minor. Does the subcommittee think realistically we might be able to turn this around for the June meeting and then vote it out for public comment?
Yes, I think so. What do you guys think? Ken?
Could be
I mean, I
doable.
think it's pretty minor, hopefully.
All right, I'll get this back to Hunter. And I will expect a draft from you guys in 10 days.
Okay.
Okay, weekend out the window, guys.
I was gonna say, that's now 3 things that I've got for next meeting.
Yay!
Come on, so.
Okay, so I'm closing that. What's next?
All right, so we're now up to 19,003, illegal contract provisions. We've been meaning to talk about this one for a while, so I'm glad we're finally here. Who's best positioned to give us a refresher and on this one?
That would be Sarah.
Dina or I could go over this one. I guess
They're tired of hearing from me, Sarah.
I will mention that I've gotten a lot of calls and emails regarding this opinion. People are very interested on the status of it and when it will be published or if it will go back out for public comment.
Okay, so, you know, I've kind of, since it's been on the agenda and we didn't get to it last time, if you could just pull it up, maybe Mimi, so I can go over on the screen some of the edits we made in response to public comments. I think we went over them already the last meeting, but these are more, the edits we made this round, I think are not as substantive, but if you could just pull it up and I'll go over them. There we go. Okay. So the first kind of primary change we made in response to the public comments is just to make it more consistent with the language of Rule 1.2.1 to refer to a violation of the law consistently. And we were using the term illegal as shorthand, including an illegal contract provision, which we still do. But a lot of this is just, you know, these red lines that you see here in the issues digest, it's just consistently using the term violates the law, provision that violates the law. And that just is so it tracks the rule more closely. The other change we made that's reflected here in the digest too, and later on in the body, as you'll see, is the term, oh, if you could say on the digest, Mimi, sorry, is we usually talked about a lawyer may not participate in promulgating or enforcing the illegal provision. That's been changed throughout to saying, I think promulgating, we got some feedback. I think that was a little bit not clear what we meant by that. So we just tried to make it clearer and use the term presenting the provision as lawful or defending its legality to a third party. So really, these are just more clarifying edits to avoid kind of ambiguous terms. So if you could scroll down now a little bit more, Mimi, to the next page. Oh, and here on footnote 2 is where we make it clear what we mean by the term illegal. And for some reason, Dina, I'll just pause here. This seems like it has a lot more red lines than I recall. But am I
I think this goes back to like, this is probably all the red lines and not just like as we went and talked about it all along, right? So
It's because the last meeting we didn't breach this, maybe, or I don't know. I ran the red line to, actually, I don't know what I ran into. Probably whatever the last version that we circulated was. Let me see. I gotta go back, but what I just ran a clean red line again.
Okay,
and sometimes, Sarah, when it moves it around, like that footnote 2, that's not all new content. We just took one part of it out. You know what I
yeah,
mean? But it's like, because it moved, then it made it all new, but it's not really all new, you know, that kind of
Yeah,
thing.
that
Same
makes
with
sense.
3. Yeah.
Yeah, this is to the public comment version. That was a red line to the public comment version that was circulated.
okay, great. So, yeah, so this was just making clear what we meant by the term illegal here in footnote 2. And that again was based on some of the public comment. And there was, although it's not showing the red line, I do recall removing some language, I thought. From
If you scroll down, you can see it. Yeah.
Yeah. Yeah.
The second sentence we removed because everyone said we should remove that.
Yeah, so that's the part. The opinion is not intended to address provisions that are legal but against public policy, unenforceable, or subject to some other prohibition. But we kept I think the second part of it. It's not intended to address situations where the lawyer knows, of course, how the provision to be unlawful, but nonetheless has good faith belief that the ruling was incorrect. The other, I think, main feedback we got from the public comments was really just about the factual scenario here that we're presenting, relating to, although we're not limiting it to a particular factual situation, and we're assuming for the purposes of the opinion that the provision at issue is a violation of the law. People were concerned about the non-compete example provided, that non-compete, including a non-compete provision in an employment contract, would not necessarily violate the law. And we tried to make it clear that we're assuming for the purposes of this particular provision does violate the law. And we also cited to some more case law too, just on that point, cases that have held that including this type of non-compete provision violates the unfair competition law, and just adding some additional authority that's reflected here in footnote 3. But again, we're not this opinion is broader. It's not intended to apply to the non-compete. It's intended to apply to including any provision that the lawyer knows violates the law. So if you could scroll down a little bit more. I think we've gone over all these other changes. So if you could go to the next page, if you could just slow down. Okay, now. We already went over these. These are, so if you keep going, I don't think the other. Yeah, if you keep going, Mimi, sorry. Yeah, these changes we kind of went over up above. Okay, I guess if you could stop at around line 1, a little bit higher on this page, maybe, I'm sorry. Okay, on line 142, we made some changes. If the lawyer ultimately decides to assist the corporation in promulgating or enforce it, again, we removed that unclear language and made it clear that including the provision for its chilling effect and presenting it to the company employees as a condition of their employment or otherwise offending the legality of the provision, that conduct is a misrepresentation by omission or an affirmative misrepresentation. So that was a lot of the comments as we've received kind of consistently have concerns about using the language maybe and not being definitive about our opinion. And we tried to clarify the factual situation more, and based on the facts we said is a misrepresentation under these particular facts, where they're including it for its chilling effect and presenting it as condition of employment and defending the legality of it to the employees. So if you could keep on going, there was one thing that I wanted to get to for the group's discussion that's highlighted here, and I think we could just maybe go to
Like
that.
171, yeah.
Yeah. So here, this is a paragraph that Dean and I talked about this, and I think we did receive public comments on this provision as well. And we are both leaning in favor of removing this particular paragraph, but we really wanted to discuss it with the group first. The hypos we presented up front don't really include the facts necessary to evaluate this issue and whether it presents a violation of Rule 4.1b. And we also are concerned about just whether it's accurate as we have it drafted currently, which you would need to research more. So this is dealing with Rule 4.1b is limited to failure to disclose a material fact necessary to avoid assisting in a criminal or fraudulent act by the client, which is narrower than illegal conduct. And here the company's decision to use a knowingly illegal contract provision for its chilling effect on employees could be, you're saying, could be viewed as a fraudulent act by the company. That particular sentence we have some concerns with. I think that might be, you know, we believe that's a fact specific situation about whether something would be fraud or not. And we really didn't present enough facts in our hypothetical to address this issue. And we do say whether Rule 4.1 applies will depend on the scope of lawyer's conduct. But I think overall, just based on the feedback we got and the way the facts are presented, that we don't really have enough information to thoroughly analyze Rule 4.1b, and we get into an issue of law to some extent about what constitutes fraud. So I'll stop there and just open it up if Dina wants to weigh in on this particular paragraph and then others.
Yeah, I mean, I kind of went to the question of like, we felt like under the fact pattern 4.1a, it was a false statement of material fact or law. And in our scenario, we sort of felt it was like a false statement of the state of the law, right? That this was somehow valid, the way our fact pattern was constructed. And that this, like you said, wasn't really enough. Whether disclosure of material fact, what was that fact that was necessary, that was different? I mean, certainly there could be a scenario similar to our fact pattern in which that could be a violation of that rule, but we didn't really develop that, like Sarah said. So the question is, do we really need it, and should we just remove it? That's accurate.
And I just wanted to also, I just was catching up on the chats, and Hunter did send a suggestion that it might be better to insert a footnote that we do not weigh in on whether this would constitute 4.1b fraud. I think that's another way we could consider as well, in addition to deleting it.
Well,
So-
fraud is defined in 1.0.1 as fraudulent under the law of the jurisdiction and a purpose to deceive. So in that scenario, an illegal contract provision designed to have a chilling effect would seem to fall within that definition. So I'm not that stressed about it, but
Yeah, I was somewhat indifferent about it too. I just don't want to, you know, yeah. So that's why I wanted to leave it to you guys, because Sarah and I didn't feel strongly either way about it, but we felt like it was important to raise it.
So, I mean, my inclination is not to include the highlighted paragraph for the reasons that Sarah and Dina mentioned, and a footnote saying we're not weighing in on this. I'm fine with. I'm concerned about going a step too far here, where the factual picture, fraud, having the pleasure of prosecuting a fraud case recently, I think I'm heightened to the factual nature of these types of accusations, and they're very complex, and maybe something appears to be fraud on its face, but it could be more nuanced than that in terms of proving fraud. satisfying what fraud actually is an evidentiary matter. So my vote would be to leave this out. But are there members who feel differently, who would want to perhaps share their views about why they would want to include what's highlighted here in this opinion? So
Yeah, and to be clear, this says, like, obviously we say it could be viewed and it would depend on the scope of their conduct and the facts. So we're not concluding it does, but yeah, we're sort of flagging it.
I kind of see it as a just like ripe for public comment to just be so unhappy with it. So unless people feel like it's really adding something or super strong, I can just see people getting really distracted by it. And like Justin was just saying, if they've represented someone or had something where they have an experience where they know how complicated a fraud can be, they see the word fraud and they're like, ah. So I don't, I also am leaning towards taking it out.
I was just looking at comment 3 under rule 4.1, specifically cross references back to 1.2.1. As under rule 1.21, a lawyer is prohibited from counseling or assisting a client in conduct that the lawyer knows is criminal or fraudulent. So it seems like that comment is kind of tying it back, or tying the two to some extent. But yeah, I'm fine with dropping it if people are concerned, but I don't per se have an issue with it.
any other thoughts on this highlighted portion?
Yeah, I think after this discussion, I'm still leaning towards removing this paragraph. I'm also okay with the suggestion to include the footnote, although I don't. Amy, it looks like maybe you deleted some stuff at the end, but I think the intent would be, if we're going to take it out, to take it out altogether.
The only thing I deleted was your note saying, can we please consider this?
Oh, okay, gotcha. Sorry, I missed that. Okay.
No.
So if we do take it out altogether, I'm just trying to figure out where this footnote, if we're going to include one, would go. Would it go at the end of the last paragraph?
Well, excuse me. There is a discussion. What is it? 140. What was 142 in the red line, where we're talking about misrepresentation, and so this topic of misrepresentation and fraud kind of go hand in hand. So that might be a place to stick the footnote at the end of at the end of the paragraph that starts at 142, just as one option.
Yeah, I like that, and we're already referencing 4.1a there, so I think that is a good place to put it.
And you want me to just make a note that you're going to develop a footnote?
Yes,
Or do you know what
that sounds good.
Okay, add footnote here. That we're not addressing something.
4.1b.
Okay.
So I think I went over really the key changes. If you want to maybe just quickly pull up, we also prepared, since it's been a little while, a summary of the public comments.
Yes.
19,
hold on 1 second. I gotta get it.
Okay. Because I don't think well, actually, before we go there, maybe I'll just open it up for discussion too, about if anyone has any suggestions about the other red line edits that we've made. I think I view them more as clarifying type edits, but with the exception of this one where we're removing the discussion on 4.1b, but I just want to see if anyone else had feedback on the opinion, and then I could go over the other document briefly.
Yeah, I had one, sorry, did I cut someone off? Go ahead. Oh, no, okay. There was just one addition that stood out to me in footnote 10 and footnote 17. There was an addition to discussion about tenant rules and regulations. And it just seemed kind of it seemed tangential or kind of untethered to the subject matter of the opinion, which, you know, I'm fine with the discussion of employment and employee contracts and things like that. But then we had these additional examples. I think it was meant to illustrate, you know, the 17,200 type of claims that come up. Those cases, as I read the footnote, were not necessarily tied to lawyers' conduct. So they seemed to me out of place. I would be in favor of removing those. And I can also say from just experience in that particular realm that oftentimes landlords find stuff on the internet and they make rules and regulations, and it doesn't necessarily have to do with a lawyer being involved. And so again, for that additional reason, it seemed kind of out of place. So unless there's a way to kind of more directly connect the tenant examples in those two footnotes, 10 and 17, I would be in favor of cutting them.
You said 17 was the other place that occurred, Justin, where we cited to the McHale case?
Yeah.
Yeah, if you could highlight the McHale case and then
It says 18, but it's not really 18 because once we delete that other footnote, it's a whole thing. Anyways, it'll be fine.
yeah, I'll go back and look at this McHale case. So perhaps it wasn't a lawyer involved in this particular case. I don't recall. But I think this was just intended to provide another example of a situation where including an unlawful provision is a violation of the law. And that was really in response to public comments where they felt that including an illegal provision in a contract isn't conduct that itself is a violation of the law. That's what some of the public comments had argued. So we were trying to provide additional examples, but we already have them in the employment law context, as you've said. So this might be unnecessary. And if a lawyer's not involved, I think maybe we should just go ahead and remove it.
Yeah, I think all of what you said makes sense. I mean, if it turns out the facts are that there was a lawyer involved and we can tie it to.
We can clarify it in the parenthetical then, but I'll look at that case again.
Yeah, okay.
Yeah, I don't think any of these cases involve lawyer conduct. I don't think that's really the point. The point is that it's a company that's having a pattern and practice of violating 17,200 and whether the lawyer is going to be complicit in that, right?
That's
and that was
true.
another example of that. So the lawyer's conduct isn't really relevant, but I do take the point that it's not another example of an employment situation. It's completely off topic to that. I think it was the intention, right, Sarah, was to support the 17,200 because we felt like that argument was very persuasive related to, you know, what Sarah just articulated, which is like, okay, you can argue something isn't necessarily a violation of the law, but certainly under 17,200, if you have a practice of doing this and violating the law, then that is a violation of the law to have those types of unfair business practices in general. So, yeah.
Okay.
Do other people feel like that's misplaced, that reference to the tenants, that situation regarding 17,200, or do people think it adds to what we're trying to communicate related to unfair business practices being violations of the law?
I agree with what Justin had said about how it's not, sometimes it's just landlords grabbing stuff off the internet. And so having not read that case, I don't think it's the fact that it's not an employment example that makes it out of place, but it's just that maybe it doesn't rise to the level that we're looking at in terms of deceptive business practices. So there would need to be more explanation of facts for it to be as applicable. So I'm okay with taking it out.
Just looking back, the area in the text refers to an illegal provision in an employment contract, and then it cites footnote 10. So I kind of agree with Justin to that extent, to the extent, this has nothing to do with an employment contract. It doesn't really add to that discussion, but it does provide another example of it. If a lawyer assists in a contract provision that's against the law.
I know there's other examples in the employment context, like arbitration and some wage and hour type. I just don't, which would probably be more on point, but I wonder if we need it,
And as someone who used to advise landlords on leases that had building rules and regulations, I can say that it's a little scary to think that we'd have to like review each of the 70 rules and regulations that they've appended onto the lease to make sure that there's nothing unlawful in there. So that's the other, maybe it's just from reading all the public comments on the last few ones that we've circulated. I just I'm like seeing places where people are gonna, like, the landlord side transactional lawyers are gonna freak out thinking that they have to suddenly like do separate research on their clients' rules and regulations, when that isn't really, like, you're not advising them on the rules and regulations.
yeah, I see your point. I don't, that's not what the opinion says in my mind. I think it's
No,
very
definitely not.
limited,
I'm playing devil's advocate
No,
in
it's-
terms of how someone could totally unreasonably read it, and whether it's worth trying to make that point when it's just an example in a footnote, after another
Yeah.
example. So
yeah. Well, I think that's, I don't, no one's really arguing for that it really should be included. I think we are trying to think of more support for that idea, at which we could do separate research on, but maybe we don't need it. And I'm in favor of removing it if you are, Sarah, and others are.
Yeah, I am. And I just, as we were talking, I was just quickly scrolling through the case, and I think after looking at it again, I think we should just strike it here in both footnotes. And I do know in one of the earlier footnotes of this opinion, we already have other authorities saying that including an unlawful non-compete violates the unfair competition law. So I think we have enough already without this McHale example.
So we just
Yeah,
strike part of it, right?
Yeah,
The whole thing, just.
yep,
Just that part, yeah.
just that part, and then
17.
Yeah,
Well, that was, oh wait, that wasn't 17, hold on.
that was, I think,
That was
10.
10. Sorry, okay, and then, well, now 18 because it got shifted, so just how much of this?
The
All of it.
highlighted yellow. No.
Oh, I'm sorry. I didn't mean all of it. I meant all of the highlighted. Sorry. Yeah.
Is that?
Yeah.
See, blah, 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 blah. Okay, and then we'll get rid of that.
Any other comments about the opinion? I think, Sarah, you mentioned you wanted to talk a little bit about some of the public comments. I have vague recollection, but my memory is not what it used to be before preschoolers, that we at least talked about some of the public comments, but I don't know
Yeah.
that we went into all of
I
them.
mean, do we need to go into them?
No,
you know
I'm
what, now
not
that I think-
suggesting, no.
No.
I'm not suggesting we go page by page, okay?
No.
Let's be clear.
I
But if there was one
don't
that
know
you
that
wanted
we.
to talk about, by all means.
No, I'm trying to, and I'm sorry on my end, I have trouble on my little laptop here. But I would just want to make sure I didn't overlook anything major that we received from the public comments, but I think we kind of went over them. Really, the main concern was just the particular example provided, and then, feeling that it doesn't tie to the language of the rule, that the kind of debate was, is including an unlawful provision in a contract itself conduct that violates the law, which we've considered, and we conclude this opinion that yes, that is conduct that violates the law. And we receive feedback from both sides. Some argued it's not necessarily conduct that violates the law, and then others provided helpful commentary explaining that that would be conduct that violates the law. And we've just tried to really be careful with the language we're using in the opinion to try to make it clearer in this hypo, and also to clarify that this is not intended to apply to a one limited situation involving a non-compete, that it's broader. So we kind of already went over it, so we don't need to go through the
and we're
summary.
not saying, oh, sorry, Sarah.
Oh, go
We're
on.
also not saying like the lawyer's the gatekeeper in that way. Like if the lawyer is putting this and saying to them that this is completely proper and not advising, then that's a problem, right? That's a violation of law. But it's not a question of, you tell your client, I don't recommend you include it, and they do it anyway, you're not responsible for that. And so I think, there's definitely like a bunch of different fact patterns that we didn't have a fact pattern on, because maybe that was controversial, like what the role. So we tried to make it clear that at the end, the lawyers, it's clear that everyone understands the violation of the law in that scenario 4, but the client's still saying, hey, but I want you to, defend the legality of it. I want you to tell the clients that it's a condition of their employment. And so we really had that fact part beefed up so that that's clear that conduct is improper, and not maybe something in the middle, which would be more nuanced and harder. So that's also the way we drafted it. And there was also a lot of public comment in favor of this opinion. I think that because there was some critical comments about it, the perception is that it was all negative in the public comment. There's a lot of public comment that was very, really thinks it's very important because of the prevalence of this problem as a, from a consumer perspective. And so, but I think Sarah she did that memo, we looked at that, and so she's basically addressed all the public comment and our response to it and how the opinion addresses it. So if someone read that and they felt like we didn't adequately address a concern that was raised, that's something that we'd be happy to talk through.
I have a question. With all those changes regarding illegal, do we want to change the title? Advising client on illegal contract provisions? Maybe change it to advising client on contract provisions which violate the law? That's what we made that change in the issues and pretty much throughout.
Mimi, do these things have titles? I feel like we've gone back and forth on whether some of them don't.
They actually, when they get published, they don't have titles. It's just the number. However, when it goes out for public comment, we put a little title next to it so people know what it's about and they know what they're commenting on, whether it's a topic that will interest them. So yeah, if you look on the public comment page, it has a number and then it has in parens what a short description of what it's about.
Our footnote says that we use illegal as synonymous with a violation of the law. Footnote 2, is it, or what is it?
But no, yeah.
Always make it just be advising client on contract provisions that violate law.
Well,
I'm okay with making that change, since it's, it's ultimately not something that
No, it
it's
won't.
just for public
Yeah, it
comment
won't be
purposes,
permanent.
and since they might not see that footnote right away, maybe I'm okay changing it.
I guess if we want to get a lot more public comments, just leave the legal in the title. That seems to generate it.
Well, I guess that's a question, which is that we've been out for public comment twice. And I that's a question, Justin, right? Whether we just voted out to the board or it goes out for public comment. When we came up with this before with the incompetent or the impaired client, I'm trying to remember when we had the same situation where there was revisions, and I felt like Andrew's kind of the guidance he was giving us was like, we should bring it to the board that there's not, we've heard everything we're going to hear. Are we going to hear something new in response to this? Right. But I don't know how that we should navigate that. I don't think it's typically out for 3 rounds of public comment. That's what I would say, but Randy probably knows more about that.
Yeah, I mean, I would love to hear from Randy or Mimi about whether they feel that this warrants a 3rd round of public comment or not, based on the changes that have been made.
So we do look at the board standard for public comment proposals does provide that proposals should be sub to public comment, but that public comment is not required in the following circumstances: to correct clerical errors, clarify grammar, improve organization, conform to specific changes in the law, update references or citations, or make similar editorial changes. To modify a proposal that has been circulated for public comment when the board deems the modification non-substantive, reasonably implicit in the proposal, or a narrowed version of the proposal, or to add or modify an appendix to the rules of the State Bar. And so the one that we look at often really is just the first bullet. Is it simply a grammatical change? Well, those things are pretty obvious. The one we tend to look at is the second one, which is whether the newest version of the proposed opinion is a non-substantive change to what was previously circulated for public comment. And you can consider whether the changes you've made are really implicit, or if they narrow the version of the proposal. And so, for example, on that last point, we were looking at an opinion earlier today with regard to files, and we looked at the issue of work product, and the opinions version that went out, or that was worded before, referred to the standard of communicated versus uncommunicated work product. But then that was revised in a way that I think broadened the scope of the opinion and the obligation of the attorney to refer to work product that would be reasonably foreseeable prejudice to the client if it was not provided to the client. And so I would ask the drafters if they think there's anything similar that has occurred with this opinion in terms of broadening the proposal or adding something that is really not reasonably implicit. I do see a lot of grammatical or not substantive changes, but that is really the question to ask when you're asking whether the opinion should be recirculated for further public comment.
Thanks, that's helpful. And I do view the most, and I'll defer to Dina too, most of these edits as clarifying information that was already implicit in the opinion, like what illegal means, a violation of the law. But we also, the only other thing that we also did just decide to remove the discussion that I believe was there to begin with on 4.1b. I don't, the fact that we're removing that, I don't know if that warrants another round of public comment or not. But that's the only thing that I would view as, I guess, could be viewed as substantive because we're taking something out. But Dina, what are your thoughts?
That's kind of narrowing the scope. I mean, I would say if you're looking at like sort of, are we narrowing the scope of what we previously put out? I do think we've narrowed it, right? I don't think we've added, we've clarified and we've narrowed. I don't think we've added new concepts here, you know.
Oh yes, I think I missed that. So narrowing it is okay then. So
I wonder if you could really say it's narrowing though, if you've already issued it for public comment with an interpretation that sets sort of a test for whether the lawyer would be subject to discipline for that provision. And now you dropped it entirely and you had a footnote saying we're not going to discuss it. Does that raise the specter that the reader would believe that it's a completely unresolved issue and the lawyer might be subject to discipline because the rule has not been interpreted in a way that limits its application? So I worry about it in that sense, since it was an actual discussion of when would a lawyer be subject to discipline under 4.1b.
Well, our analysis there was it's fact dependent, right? I mean, that's, yeah, which we could put it back in if that's the concern.
I was looking, there was
Yeah, and
I only saw one public comment that dealt with that by Stanley Lamport, and he disagreed with the conclusion we had. So removing it would seem to be consistent with the one public comment on point. I don't know if how that factors in.
Yeah, and the other point I was going to make, Ken, is that also one of the reasons for removing it was just because you don't really have sufficient facts in the scenarios to address that issue, which is, as Dina said, why the conclusion was really, it depends on the facts more so.
Mhm.
I think if you're talking about truly narrowing the opinion, then it would be a revision to the opinion that would say 4.1b does not apply at all under these facts. But I don't think that's what the removal of it is intended to send as the message concerning that rule's application in the context of this opinion. But I don't think we should either, I'm not advocating that we say 4.1b does not apply. But that would be, to me, the clearest case of the next iteration narrowing the prior version of the rule.
So just to play this out, and I'm not suggesting that this is what we will do, but if we did put this out for public comment again for a third round, what's the how many days would it have to go out for public comment?
I've seen a third round of public comment go 60 days or 45. I think 60 is typical though. 45, it's only if usually it's time sensitive. Sometimes making a 45-day deadline doesn't give local bar associations enough time to consider an opinion and write a public comment letter. So I would say probably 60 days.
Okay, I mean,
It would, if we sent it out this, like, let's say we were to send this out for public comment again, it'd probably come back before the July meeting.
I don't really know what public comment would do here to benefit us or allow the public to weigh in on anything that's really new or different that wasn't just responding to the public comment we already received. So, but I also want to be, I also don't want to shortchange the public. If there was something that anyone here, including, you know, Randall, Mimi, that you thought that the public should have an opportunity to comment on. I'm not personally seeing it, but I don't, honestly, I don't have strong feelings about this. It's the other option is to sit on it for 3 weeks and then make the decision in June as to whether we think public comment is appropriate or whether we want to vote it out. So that's another option.
Justin, the other big picture point that I've tried to communicate over the years to COPREC is that COPREC is uniquely situated among sub-entities who report to the board because COPREC has been delegated really an incredible privilege to make the decision to issue things for public comment on its own authority. Almost any other group, staff, committees of the bar, they need to go to the board and affirmatively ask for authorization to issue something for public comment. And so it's something that you should jealously guard and not feel that, I mean, create an impression that the board can't trust COPREC in terms of deciding when to put things out for public comment. So from my perspective, I would always advocate you being very conservative in looking at those exceptions because you do enjoy a privilege that other groups don't in being able to make your own decision on whether to issue it for public comment or not.
Sorry, I was going to say, let me turn it back to the folks who are on the subcommittee and, you know, digesting all of this conversation. Where are you landing?
a couple of things. I don't really know. I'm trying to understand what Randy's point was. I feel like he would like us to send it out for public comment, Randy, but I'm not sure what your ultimate conclusion was, the way you phrased that. I didn't really know what you meant that you, with respect to that privilege, whether we should be cautious about doing it or we should err on the side of always doing it. But
I think err on the side of always doing it.
yeah, I mean, I feel like this is very similar to the diminished capacity opinion, where there was a lot of edits that were consistent with what we'd done before, and we didn't send it out for the third round of public comment. So I personally think that we have gotten a ton of feedback, which is fabulous, and we've responded to that. That Sarah's put together a detailed memo for the board about all the public comment and how we've addressed it in the opinion, which was for this express purpose of providing that to the board, right? And for ourselves, but as something that Andrew had recommended was really helpful in that process. But I think we should take a straw poll, and I think that if we're going to vote it around for another round of public comment, I don't really want to wait 3 weeks and then decide we're going to do that then, right? This has been around for a while. I think it's an important opinion to go out, and I think that if we're going to send it out for public comment again, then we should decide that today and not wait for 3 weeks. That's my view on it.
I don't know if you guys saw the group chat, but Hunter says that him and Toby agree that it has been narrowed. So maybe that matters. Maybe we should go back up for public comment.
That what? I didn't hear the last thing you said.
Hunter and Toby says that they agree that it has been narrowed. I'm assuming they're referring to the opinion. So.
And you're saying that weighs it.
That weighs it. Yes. Yeah. I mean, that's a reason. If it has been narrowed, then that's a reason for it to go back out for public comment.
To go back out. Okay. Well, why don't we do this? Why don't we get?
So that is true. I think I'm just getting confused. So if we do narrow it, then that's something considered a substantive change that warrants public comment.
I heard that
right?
just the opposite way.
I heard it the opposite way too.
Yeah, that's why I'm getting confused.
Then.
That they're saying that they don't think it needs to go out for public comment, but maybe we just need to take a straw poll or. Yeah.
But what is the rule? If someone could just clarify it.
Yeah, Randy,
I'm confused. Sorry.
Randall, can you clarify the whole
Sure.
whether narrowing means we do or do not need to send it out to public comment, and then we'll take the straw poll.
Yeah, the board's manual says that public comment is not required to modify a proposal that has been circulated for public comment when the board deems, and here you're in a special case because you get to decide this, the modification non-substantive, reasonably implicit in the proposal, or a narrowed version of the proposal.
Correct.
And when staff has looked at that in the context of ethics opinions, we've looked at that in terms of narrowing the exposure to a disciplinary violation in comparison to how that was posed in the earlier version of the opinion. And if you had an opinion that said XYZ constitutes a directly adverse conflict of interest in a section of the opinion, and then you reverse that analysis in your subsequent opinion and says XYZ under these facts does not constitute a direct adversity conflict, then I think that's the clearest case of the opinion in its current version narrowing the disciplinary exposure that was held out in the prior version of the opinion. But things can be more nuanced than that, I suppose.
No, thank you for for explaining again. So why don't we do a straw poll? Mimi, can you help us out with that straw poll, and as to whether folks think that we should send this out to public comment or vote it out for the board's consideration?
Okay. If you vote yes, that means you think it should go out for public comment again. This is just a straw poll. It's not a formal vote. Okay. Justin Fields?
Yes.
Ken Bacon?
No.
Sarah Bonola?
I'm sorry. Yes, as we're voting it out, no public comment.
No, yes means yes, I think it should go out for public comment. No means I don't think it should go out for public comment.
No.
Okay. Elizabeth Bradley.
Yes.
All right. Cassidy Chivers,
No.
Toby and Linder,
No.
Brandon Krieger,
Yes.
Joel Mark.
Abstain.
Really? Okay. Eleanor Mercado, Bill Munoz,
No.
Kyla Rowe,
No.
Hunter Starr.
No from Hunter.
Okay. Well, then the noes have it. It would have
Okay.
been 3-7 and 1 abstention.
Very good. So then it seems to me that subject to, I think, drafting that one minor footnote, that the committee is inclined to vote the opinion out for consideration by the board for publication. Am I missing any steps, or are we prepared to have a motion on that?
Nope. We are prepared to have a motion on that.
Okay, anybody want to make a motion?
I
I'll
move.
make I'll second it.
Okay, so motion made by Ken, seconded by Bill Munoz. Any further discussion? Otherwise, I'll take the vote. All right, Justin Fields.
So just to be clear, yes means,
Oh, so the motion is to approve the opinion for publication.
okay, yes.
Ken Bacon,
Do I abstain? No, I'm just kidding. Yes.
Sarah Bonola,
Yes.
Elizabeth Bradley,
Nope.
Cassidy Chivers,
Yes.
Toby and Linder,
Yes.
Brandon Krieger,
No.
Joel Mark,
Abstain again.
Eleanor Mercado, Bill Munoz,
Yes.
Kyla Rowe,
Yes.
Hunter Starr.
Yes from Hunter.
Thank you. Okay, the motion carries.
All right,
2, 1, 8,
very good.
1.
And so as a matter of timing, Mimi, do you all know when the Board of Trustees is likely to consider the opinion and whether they're going to publish it based on their current calendar and next meeting?
I believe their next meeting, Randy, correct me if I'm wrong, is July.
Okay, great.
We can check.
Sounds good. Why don't we take a short, just 3-5 minute stretch break, and then we'll jump into lawyer's expert witness. Sound good?
Sounds good.
All righty.
We're ready to start whenever you are.
All right, because that means we're back.
Yes.
All right, so next up is another opinion we haven't had a chance to talk about for, I think, at least a few meetings, lawyer's expert witness. Is this, Sarah, is this you as well?
Yes. I can take the lead on this one.
Great.
And I think there are really two primary issues in the round of revisions. It's been a long time since we discussed this opinion at a COPREC meeting. But there are two issues that I wanted to raise for the group's resolution. The first one, though, I think is more of something that we'll have to follow up with the subcommittee on, because it's really just scenarios, and this is opinion that has been going on for a while, and Adam, our former committee member, was initially the lead drafter, and I've just always struggled with scenarios 3 and 4 in terms of understanding the differences between these two hypotheticals. And given the length of this opinion, in working on drafting this, we've tried to kind of not make the reader have to go back and forth between the facts and the analysis. And so as part of the heading of each scenario, we're trying to succinctly explain kind of what each issue addresses. And 1 and 2 are a little easier. 3 and 4, the differences are more nuanced. And so we've tried to do that with some parenthetical descriptions, but I don't think, I think it could be improved. And I really welcome improvement on just the parentheticals for scenario 3 and 4. And that might not be something that's easy to discuss right now, because I'm not sure how many of you have really carefully focused on this particular opinion, but I really, as you're looking at that, if you can think of a way to help improve 3 and 4, and if anyone's already considered that issue and has suggested language, I'll stop now if you want to suggest it now. Otherwise, I'll follow up with the subcommittee members after this meeting on that particular issue. So not hearing anything. The other one is something that I did want to open up for the group's discussion. And that's, I think there's only one other highlighted issue. Mimi, if you could scroll down to it. And I'm sorry, I don't have the line or page handy, but it's also highlighted in yellow. Because as you can see, there aren't a lot of changes here. Wait, oh, here it is. And so this is addressing scenario 3. The issue is, and we've kind of referenced this in relation to all of the scenarios where the lawyer is serving as either an expert and then the law firm serves as counsel for the client, or we switch the scenario around. But in each situation, we've kind of discussed, aside from the ethical rules, there are still standards that have been developed in case law that even if it's ethically permissible under the rules, there's still a risk of disqualification. And so we wanted to point out that risk, and we've done so, I think, with all of the scenarios. But the issue is here is we have at the end of the sentence, law firm may need to disclose that risk to its client pursuant to Rule 1.4a. And although it's not shown in the red line or in this draft, as I was considering that sentence again and whether we should change may need to should or be more definitive, and say must, I was looking at 1.4 again, and I'm questioning if 1.4a, which deals with you should reasonably consult about the means by which to accomplish the client's objectives. The others don't really seem applicable, but A2 could potentially apply. But subsection B talks about explain the matter to the extent reasonably necessary to permit the client to make an informed decision regarding the representation. And so I don't know if we should narrow it to 1.4a as we've done so here. I think potentially 1.4b could apply to the situation, but I also just would like the group's feedback on what they think, if Rule 1.4 applies at all, should we have this sentence here where there could be a potential duty to disclose? I think it's certainly a good practice where the lawyer, the law firm have roles as an expert in representation of the client where there's a risk of disqualification, disclose that risk. And does it fall under a duty within the meaning of 1.4? And if it would be helpful, we can go back up and go over kind of, and this is kind of an issue for discussion. It's for some reason, it's only addressed in scenario 3, but it's something that potentially could apply to the other scenarios as well. Where there is a risk of disqualification caused by the kind of role of the lawyer as both an expert and the law firm as a attorney representing the client, but there's a risk that the law firm could be disqualified. Is that something that needs to be disclosed to the client even if it's ethically permissible to take on both of those roles. And I know it's kind of the end of the day and I'm not hearing a lot of people responding. And these are really kind of complicated factual situations and scenarios. So it may be something that we need to kind of consider more thoroughly through the subcommittee. But I'll pause now.
Well, it seems to me that if you kind of look at the language of 1.7, where, you know, what's the new language now, substantially or could substantially impair the relationship. I forget the exact language. Kind of using that train of thought, I think it should be should as opposed to may need, because, you know, that's certainly reasonably foreseeable. If you want to use the old version, you know, 3310, that's certainly a reasonably foreseeable consequence of this situation, and one that must be disclosed, and, you know, you get informed written consent. My view is as one who does expert work, I mean, I think we ought to say should as opposed to may not or may need, because, you know, that is very foreseeable, and that's something that the client should know and be aware of and make a decision accordingly.
Yeah, one thought I had on this related to 1.4 is whether under our factual scenario, I'm not sure what we're saying the seriousness of the risk is, but would it rise to the level of being, you know, a significant development under 1.4A3, that the lawyer would have an obligation to inform the client, hey, there's a possibility of disqualification here. Would it constitute a significant development, such that it would be appropriate to use should instead of may need? And I haven't thought enough about our factual scenario, applying that to this opinion, but that was the 1.4 hook that caught my attention.
Well, certainly, I agree with you on that, Justin, because certainly if that disqualification motion does come, then that is certainly a significant development that clearly the client needs to know about. So I agree with you there.
So just as another, well, sorry. So any other thoughts on this question?
I tend to agree with Bill. I'm thinking it should say, well, it should say should, yeah. It should be a should. And I was looking also at 1.7C1, even where B does not apply. Lawyer shall not represent a client without written disclosure of the relationship. Within paragraph D, where the lawyer knows that another lawyer in the lawyer's firm has a legal, business, financial, or professional relationship with a party or witness in the same matter. So if you got a lawyer in your firm who's the expert for the other side, I'm trying to see why that wouldn't trigger that. Which is, at minimum just says disclosure, which is what that sentence says.
Yeah, I mean, I see Hunter's point in the chat, and I think that's right, Hunter, that we really, I think, need to look back on what the factual scenario here is. If it's so black and white that we can say should, okay, that's one thing. But if it's vague or we don't have enough facts to really opine on the risk, you know, that would counsel in favor of keeping may need. So I think that's maybe a threshold question here is whether we have enough facts to go so far as to say should, or do we need to kind of water that down because it might depend on the circumstances. And honestly, this is such a dense opinion. I couldn't tell you offhand whether the facts cancel one way or the other.
Yeah, and I actually viewed, I know Hunter's here, but, and maybe you could explain, I viewed Hunter's comment a little differently, and maybe I misunderstood, but I was understanding that Hunter was saying may need might actually be stronger because it's just that in certain circumstances, it actually is required that you make, that you provide this information to the client, where should implies more of just a best practice, something that's not necessarily required, but may need says it actually might be required under certain facts. Which I get that point, but maybe I'll pause. I don't know if Hunter, if you can shake your, I don't know what you, but that's how I understood your chat to mean. But I do agree that this is a very dense opinion, and I think we need to like just go back and carefully look at the facts and consider this issue as a subcommittee. It's hard to open this up for the group feedback, and it's difficult for me as well, even though I've been working on this, because I wasn't involved in drafting the initial fact patterns, and I've always struggled with distinguishing 3 and 4, and I need to kind of get a better understanding and maybe even rework or those facts to make it very clear what we're addressing here. So and then I just wanted to point out too, since we were going, because I know that Hunter and Toby are having some difficulty given where they are. So I just wanted to make sure we address Toby's point too, which she just made in the chat, which is she believes 1.4A3 makes this a significant development if the testimony creates a risk of disqualification. And I do agree that significant development, and I had that in my notes as well, that there is there is potential a duty under 1.4A3 to the extent we find this is a significant development. And I tend to agree with Toby that, if there's a risk of disqualification, that could constitute a significant development within the meaning of the rule. So I don't know what others think about that. If there is a risk here, do others view this as a significant development that needs to be disclosed under 1.4A3?
Yes.
I mean, if a lawyer knows that there's a real, this is my own words, this is not the law, but there's some kind of possibility out there that will in some way impair the attorney-client relationship. And then it's not just theoretical or hypothetical, it's based on actual events and circumstances like, this scenario. How could that not be a significant development? That's kind of my own gut reaction. But again, it goes back to what is the actual factual scenario that we're addressing. And, these types of disqualification scenarios can be somewhat convoluted. And so it really depends on how these facts ultimately play in our opinion, and how far we would therefore feel comfortable saying it is or is not a significant development. If it's just a hypothetical risk, as opposed to something that crosses whatever threshold we feel would lead to a significant development. But I think it has to be something more than just theoretical.
Yeah, and I think if it falls under the, if there have been examples and cases where the lawyer was disqualified, even though it wasn't found to be a violation of the rule, to me, that favors the fact that it would be a significant development because it rises to the level of situations where disqualification has been found pursuant to case law. But I think the other edits that I've made to the last draft, I know it's been a while, they weren't major edits. Again, they were more in the nature of clarifying because we have had this opinion out for a while, but I really would like some assistance from the subcommittee members, and I welcome it from anyone on just, if you guys could help out with scenarios 3 and 4 in particular and focus on that when you look at it. then also consider this issue that I've raised in the highlighted note, that would be helpful. Because I think those are the two most difficult fact patterns that we're addressing in the opinion. I feel more comfortable with 1 and 2, and 3 and 4, I think could use a little bit more work. So I will continue to work on that before the next meeting, but I welcome others to weigh in.
Yeah, I'll just say, go ahead.
Oh, I didn't have anything else.
Oh, I thought someone, okay, it may have been my feedback, but it was just me talking. Okay. Eyeballing this, after not reviewing it for several months was very helpful to, I think for me at least, have some more clarity on aspects of the opinion that I think are harder to digest, and where we can combine concepts, narrow them, simplify them. And so I have some thoughts on that I'll share with you offline. But bottom line is, I think that when we distill some of these concepts and shorten some of the paragraphs, it's going to allow the reader to better understand our analysis and conclusions. A plus B equals C, something more simple. Right now it's like A plus F minus G equals C squared. It's just really hard to digest right now, and I haven't been able to put my thumb on it as to why, but I think I'm seeing some opportunities to shorten and change some wording. So and if others have thoughts like that, that's going to help make it easier to read, because right now it's just so dense, and you have to, I can't think that hard anymore. When you've got all these different scenarios with it, he's an expert here first, and then he's a lawyer, and then it changes. It's a challenge to get through and internalize in one sitting. And so the more we can make it easier for those readers who aren't as familiar with legal ethics, who are trying to digest this, I think that's really the challenge right now where we have with this opinion, because it's very interesting stuff. It's just hard to go from that A plus B equals C type of reading that I'd love to, if we can make it that simple. I know that's oversimplifying. I appreciate that, but close to that would be best. So I would encourage anyone who has suggestions in that regard to send them to the subcommittee. I'll do the same as well. And I think maybe the next iteration will benefit from having, that close read and feedback from not just the subcommittee, but those with a fresh set of eyes on this one, because it really would benefit from that.
Justin, I have a question in that regard, which is not just limited to this one, but in some of our opinions in our drafts where we have scenarios, we do like in this one, where we go scenario 1, 2, 3, 4, and then we go to the discussion, 1, 2, 3, 4. In others, we go scenario 1, discussion, scenario 2, discussion. I find the second approach to be a lot, well, at least it gets my attention focused more on exactly the scenario when I'm considering it immediately below the discussion immediately below the recitation of what the specific scenario is. And maybe we could have or think about a consistent way of handling that stylistically.
Yeah, I mean, I do think it depends on the opinion, how long it is, how complicated it is, but it's a great point, Joel. I think take the contingency fee agreement opinion, right, that we talked about earlier, how that's structured, where you have the hypothetical and then the analysis. That's another good example where you have fairly complex and a number of different scenarios, but it reads pretty understandably because of the fact that it uses the second structure, the one that you prefer. And at least I would say, let's think about for this expert witness opinion, whether that's maybe that's one of those things we just haven't been able to put our thumb on. And maybe that's going to make a difference in terms of readability if we structured it to have the scenario followed by the analysis. So I think that's definitely an option to consider. And maybe we decide, that doesn't work for whatever reason, but certainly I think that we should, eyeball that and see if that actually helps. I think that's a good and fair observation.
I'm gonna ask for Sarah. Is there anybody else that wants to join this drafting subcommittee? They only, right now, I believe it's just Sarah, Brandon, and you, Justin, and maybe having additional people to bounce ideas off of might help. So if you want to volunteer, send me an email or send Sarah an email and I'll add you to the drafting team.
If you need someone else, I'll be happy to join in.
Thank you, Joel.
Great. Well, any other feedback on the lawyer's expert witness opinion? So I think realistically, we will hopefully turn to it in July. Certainly not for June.
Yeah, I think that makes sense.
Okay. Okay, great. So why don't we, unless there's anything further, why don't we move to our next topic, which is proposed amendments to the rule of professional conduct by the Civility Task Force. I don't know if Mimi or Randall, if you have a primer here that you wanted to provide on the memo that we received and the task before COPRAC.
Sure. The memo and the materials that Mimi prepared, excerpts from the board agenda item that went to the board at their March meeting, the resolution that they adopted. They were presented with broad proposals for certain changes, certain reforms from the California Civility Task Force. Among them were proposals to change NCLE, to modify the attorney oath, and the one most relevant to COPRAC, proposed changes to the rules of professional conduct. With regard to the proposed changes to the rules of professional conduct, the board passed a resolution asking COPRAC to review the work of the Civility Task Force and then to report back with proposed amendments that basically COPRAC would feel would be appropriate to make given the role of the rules as disciplinary standards. So it's basically assignment to consider rule amendments developed by another group and to give your own independent judgment on those amendments back to the board so that the board can decide what it wants to do next with these. And I think a public comment proposal is likely if there's something inspired by what the Civility Task Force has done that COPRAC would support as a recommended change to the rules.
Thanks, Randall. I had a couple of questions maybe to help set the stage here. I couldn't help but notice that we don't have an immediate turnaround date in this memo. So what should we take from that? Is there a realistic timeline that's been proffered for us to provide our feedback?
So, but I think before the end of the year, we'd like to have something come back to the board.
Okay. All right, that's helpful to know.
Mm-hmm.
And then in terms of the sort of redlined proposals that are attached to the memo, is that draft language from the Office of Professional Conduct Competence for us to consider as potential revisions, or do these red lines in the rules that's attached to the memo, does that derive from somewhere else?
So that is Appendix 8, which is an excerpt from the actual Civility Task Force report. And those are the proposed amendments developed by that body.
Got it. So the Civility Task Force drafted this language and is asking for our, input on it and how we would revise it, or if we would revise it, where we, things like that.
Exactly.
Okay. All right. So in terms of process, and I'm open to anyone's thoughts here, it would seem to me that we would want to, especially given that we don't have to do this immediately, that it would be beneficial to have some kind of, I don't know what you want to call it, a working group that would take the laboring or similar to what we did with the paraprofessional rules, and then present that, their conclusions and analyses to the committee as a whole for a broader discussion. So that would be my inclination, is to set up another working group. But I welcome you have different thoughts about how we should do this.
I agree with you, Justin. I just had a question similar to the question you raised, and Randall, I'm not sure if you can clarify, but I thought that when I was looking at it, it looked like there were red lines to the proposed Civility Task Force red lines. So red lines on top of red lines. So are you saying that's all from the Civility Task Force? I thought part of it was from staff, state bar staff, some of the suggested edits and comments. Maybe I'm just misinterpreted.
So as part of the Civility Task Force's consideration of proposed amendments to the rules of professional conduct, I think there were 2 former chairs of COPRAC involved who did go informally to Andrew and myself to seek some technical input. And so there were comments and red lines that were shared with that group. They were not officially from the state bar or the board. They were just technical assistance provided as a courtesy. Just Andrew and Randy's thoughts on their proposed amendments. And
yeah, no, it was helpful. I wanted to understand what we were looking at. So
that's another document that I don't think we actually included at this juncture. We wanted to focus on the actual Civility Task Force report and their proposals, but
Gotcha.
Certainly the working group ought to look at that.
Okay,
Wouldn't want
that makes sense.
that technical information not to be considered as part of the exploration of this.
That makes sense. And I just also wanted to raise one issue. Because I am a member of Civility Task Force, I don't know if that means that I can't be part of the subcommittee or not, if there are any conflicts with that, but I just wanted to mention that I'd be happy to work on it on the subcommittee, but I don't know if I should, since I am a member of the task force. I wasn't on the rules subcommittee on the task force. I was on the CLE one subcommittee, but just wanted to point that out.
Well, just to drill down on that, I mean, I don't view a conflict or anything, but have you already had a chance to weigh in and provide input and see these revisions before, or is this also new to you as it is to us?
No, I've had a chance to review these revisions previously. I didn't work on the drafting because there was a subcommittee on that, but as part of the larger group discussion, I've seen these revisions previously.
Well, why don't we see if we have any volunteers for the working group? Mimi, Randall, I would think, and Sarah, Dina, let me know if you think differently, but somewhere along the lines of 3 to 5 people would be appropriate for this task. I don't know what our max is, if 5 is too much, but
I think 5 would be appropriate.
Okay.
What do you think, Randy?
Yeah, so if it's not an officially formed sub-entity of COPRAC and we're just having volunteers report to staff their interest in serving, then it's not a separate deliberative body. And as long as it's not a majority of the main body, then we can have those folks communicate with each other without running afoul of the Open Meeting Act.
Okay.
And I'll mention that Hunter has volunteered, right, Hunter?
I'll volunteer.
And Delmiros.
I'll volunteer.
Okay. I think that would work. We could have 5 members and then either Justin or Dina can be a advisor to the group.
so
Amy,
5,
did you get, oh, sorry.
no,
Yeah,
I'm sorry, go ahead.
Cassidy, I got you.
Okay, thanks.
So 5 plus an advisor.
I'll put Dina as the advisor.
Okay, so we have Hunter,
Okay,
Bill.
but maybe
Actually-
if we're making, if there's gonna be like till the end of the year, we're making comments, remember my term will be up in
Right,
September.
maybe we'll make Justin the advisor then.
That's fine. That's fine.
Sorry, okay.
And Toby raised her hand too, just I wanted to say that. She wants to be a member.
Randy, we are getting very close to having more than the majority. So 1, 2, 3.
How many do you have now? And
Right
could you
now I have,
recap the volunteers?
so Sarah, Justin, Hunter, Bill, Cassidy, and Dina.
I think Dina was suggesting she be excised from the,
Okay,
Yeah, and Toby, not me, yeah. And then
but
we didn't,
Toby's all, just so you know, Toby's also going off as well. You guys are both terming off at the same time,
okay.
but I can add Toby for now. That's fine. Just letting you know.
All right. Okay, great. Well, given the timeline on this, we built in some time, assuming that it might be a quicker turnaround, but it's not. And so I think it probably makes sense to first let the working group discuss these proposals before we open it up to the group as a whole. So unless somebody feels real strongly about commenting on these red lines in the State Bar memo, I would be inclined to hold off on that until the working group has a
So
chance to weigh in.
Justin, it does look like the last meeting of the board is November
November.
17th and 18th. So
Okay.
we need it in time to be posted for the board's agenda for that meeting.
So what is that? Where does that put us? Say November 1st, somewhere around there.
More there because we need to have it reviewed and remediated.
I believe our first meeting of the new committee year will be October. It usually is October. Let me double check right now for you. Schedule, meeting schedule.
Yeah, I think that's usually when it is.
Yeah.
Okay, so we'll want to vote this out by the October meeting.
October 14th.
Okay. All right. That gives us plenty of time. Good.
And I'm assuming this, so is the assumption that this will not be discussed at the next meeting? It'll more likely be the July meeting.
Yes, correct. Yeah, that'll give the working group a chance to meet in advance. And then we can see, you know, at least get an update on where the working group is. We may not have a substantive discussion until the following meeting, once they've, you know, like we did with the paraprofessional rule, have some kind of detailed submission ready for discussion. So at least to check in for the July meeting, and then we'll see how far the working group has gotten. If we can go further in the discussion, great. All right, well, it's 2:48, so we've made really good time today. Thanks to everybody. We did have 2 items in the time permitting section that I don't feel compelled to get to unless there's any questions that those who are working on those particular outlines or opinions want to raise today. The first was 21-333 in-house counsel outline. I don't know if that's Cassidy or someone else. Was there anything that you wanted to raise with the group, or at least let us know where you are at with that process of drafting?
Yeah, I think Dina and Sarah and I were working on this outline. It's kind of been, you know, put on hold since the last like 2 or 3 meetings ago. But I think what, and Dina and Sarah, let me know if you agree, but I think just big picture, we want to decide how this opinion should be shaped up, whether it's going to be sort of a overall, these are the ethics issues that impact in-house lawyers, or are we going to narrow it to more just the hypothetical scenario that I think really deals more with, focuses more on conflicts. So is it just going to be, is it just going to be, you know, this is how you ethically generally you know, serve as in-house counsel, or are we going to kind of drill down on some more meaty issues?
Is that a topic that you want to put on the agenda for June to talk with the committee as a whole about, or is that something you want to work through first as a subcommittee?
I would rather, and again, if Dina and Sarah and whoever else wants to be on the subcommittee, I would rather have it be on a subcommittee, because I think I'm going to be out for the June meeting because I'm traveling, and I just realized that I will be in New York on that Friday. So my apologies for that. So the July meeting is certainly better for discussion.
Okay. And who's on this subcommittee right now?
I don't know. I think volunteers were, but I don't know if there are any.
And I'm looking it up right now.
I'm just wondering if there's an open spot.
So yes, there is. So this is for Cassidy's, wait, hold on, I'm missing it. We're talking about 21003, correct? Yes. It's Sarah, Cassidy, and Dina's the advisor.
Okay, well, not to put anyone on the spot, but we do have one more open space for in-house counsel. So if you're interested in joining that subcommittee, it's another opportunity to get involved and help out with an opinion, at the ground level, which, is the most satisfying as opposed to picking out someone else's work product. So I would encourage anyone who has the bandwidth to volunteer. It's going to be an interesting, having given a 10-minute shtick on this at the symposium, it's a very interesting topic, and I would encourage you to write to Mimi and let her know that you'd be interested. And I think we could use one more person on that committee to help marshal that to the next stage.
Yeah, and we're always better as a committee when we share the load and when people take opportunities to get involved in matters, and it's not like the same people doing the same thing. So I'd encourage those of you that are thinking about getting more involved in some of these opinions to do that, especially since we're going to be having a sort of a change in the committee in a couple months too. It's a good opportunity for people to sort of commit to the opinions going forward. That's my 2 cents.
Kyla has volunteered to join the subcommittee.
Yay.
I think that's terrific. I mean, since we have a little bit of time, but we're still going to leave, we're going to get out of here really early. Don't worry. But I just want to say that the committee, we've really tried to evolve it over the last few years. When I was our first year, it was second, third, and leadership, and they were drafting the opinions. They were on the committees, and the first years on the committee didn't have much to do, quite frankly. And really, we want this to be open to everybody and feel like that you can volunteer and be part of any opinion, of any working group. We want everybody involved. We need everybody involved because we're a much smaller committee than we were in years past. So by all means, join as many opinions, working groups as you'd like to volunteer for. The more the merrier. It doesn't matter if you've been on the committee for 6 years or 1 year. And we really encourage those of you who are, first, second years, especially to get involved like that. So thank you, Cassidy, for the update. Look forward to talking about where you're at in the decision-making process about the scope of the opinion for July.
So just so I know, so Cassidy, you're the lead drafter on that opinion? I had it as Sarah, but I can switch it. I just didn't know.
Well, I don't want to step on any toes, but
No, I think it should be Cassidy.
So
I noticed that in the agenda as well, or the assignment agenda, but I think it should be Cassidy.
Okay.
So.
Yeah, thanks. No problem, Sarah. You've been busy, I can tell.
Okay.
I'm happy to do it.
Perfect.
I was just saying, you have a lot of experience in that, and yeah, you took a laboring oar, so yeah,
Excellent. The other item that we had for potential discussion was 20003 flat fees. I don't know, Ken and Joel and team, if that's something you wanted to discuss today, or if you'd prefer to wait till the June meeting.
Well, at the last meeting, I kind of invited some feedback, but I didn't hear anything in the interim. I don't know if anybody's had a chance to look at that or give it some thought, but there's some touchy issues that we've been kind of struggling with as a subcommittee, that we kind of wanted the input from the committee as a whole. One of those deals with, what should be disclosed about a flat fee agreement. I mean, the rules as they're written, when the rules revision went through, it was you disclose that it's going to go into an operating account, but you have the right to have it go into a trust account, and you're entitled to a refund. In my view, and I think some of the other committee members, and I want to speak for them, that's probably pretty minimal. It doesn't really disclose all the foreseeable risks of the money going to the operating account. Cases and other bar associations have required essentially more of an informed consent type of disclosure there. It would appear to me, and I don't, Randy, maybe you can chime in on this, that the Rules Revision Commission, I guess, opted not to go with an informed consent and have a very limited disclosure. So to the extent that we're thinking something more than that is required, that might run afoul with what the Rules Commission was thinking about. So that's one of the issues, and along those lines as well, I guess, if it's going into the operating account at the outset before any of it's been earned, the question is, whose money is that, and can it be spent? I think kind of implicit in permitting it to go into a lawyer's operating account was that they could spend it before they actually do any work, which would seem to run afoul, and in my view, of new rule 1.5D, I think it is, says you can't have something that says it's earned on receipt. So if you can't say it's earned on receipt, then it's not your money. But if it goes into your operating account, is it your money that you can spend? It seemed like there's some conflict there. And the other one would be opening up kind of an old subject, with renegotiation of a flat fee. Is that something that would trigger Rule 1.8.1? The COPRAC dealt with that about a decade or so ago. They had a draft opinion that concluded that then Rule 3300 did not apply to a midstream modification. The Rules and Development Committee rejected that opinion. It was opposed by the Office of Chief Trial Counsel. It was opposed by the Committee on Mandatory Fee Arbitration and others. RAD rejected that, but there's really nothing out there that specifically holds that unless there's an adverse pecuniary interest or something that otherwise triggers 1.8.1, the midstream modification is subject to that rule. But I think the circumstances with a flat fee where you're, as the lawyer, made a representation, this is what it's going to cost you, unless it's something that the client somehow triggered. If the lawyer basically blew it and then wants more money because it's not profitable, does that trigger 1.8.1? So somewhat touchy subject. So we kind of wanted to get the feedback from the committee where they think on those issues, because that could help form us, where we're going with this opinion. So I don't know if anybody had any thoughts on that, or if it's too late in the afternoon and you want to think about it for 3 weeks and come back on June 3rd, but we would like feedback on this. I don't know, Joel, Brandon, you got anything to add? Or
I'm sure we're all going to go home, drive home, and be thinking about these 3 issues. for everyone on the
I would
committee.
certainly hope so. And well, instead of the Warriors game, that would be better, but.
I guess I just had one thought on the, you mentioned that the Rules Revision Commission kind of poo-pooed the idea of informed consent. If we haven't run that down to verify that, maybe Randall can help find the documentation on that question if we don't have it, so that we can.
What I found was the version of 1.5 that's on the State Bar website has some of that background information in it. It seems like the public comments, originally there was no exception that allowed you to put it into the operating account. And there was a lot of public comment against that from it was immigration lawyers, criminal lawyers, others that do a lot of flat fee work. If I was understanding correctly, a prior Rules Revision Commission came up with something that commenters said was not informed consent and not disclosure, but something along the line. I think they call it like informed disclosure and creating a whole new thing. And this rule 1.15B with the exception was somehow meant to accommodate those competing interests. So it allowed, and I think my view was implicit in all that was, saying, disclosing I could put it in my operating account and you're subject to refund and you otherwise have the right to have it go into the trust account was, let the lawyers spend it even if they haven't earned it yet, and even though they may have to refund it, which I could just say from the fee arbitration context is problematic because I've had any number of cases where that occurred and they didn't have the money to refund the fee. So, but there's probably more out. That's all I could find on the website.
That's a very good summary, Ken. The big picture issue, of course, is that for many years under the California rules, an advance payment for fees was treated differently from advance payment for cost in terms of what was required to be treated as funds held in trust. And so the big change was to require any fee paid advance to be placed into the client trust account. And what that did engender was sort of an access to justice issue with regard to flat fees being used in those areas of law where there could be impact on certain clients. And so clients who pay flat fees to get access to criminal defense attorneys, clients who pay flat fees in bankruptcy cases. And so there was a consideration of limited exception for flat fees paid in advance, not to be placed in the trust account, but to not characterize that act, that conduct as constituting a conflict on the same level with, direct adversity or other conflicts that require informed consent. And so that's where we did end up.
Yeah, because the comments talked about, with paragraph B, the advance funds to be held in the law firm operating account. And held seemed like an odd term because, why have the ability to put it in your operating account if you have to hold it until you do the work? So those are the issues, and I'm anticipating from the looks on the screen here that everybody is going to deeply think these things through the whole rest of the day and the weekend.
Undoubtedly.
Ken, there's one other practical issue of that, which I didn't discover until recently. I was retained in a matter, and I think I got a $7,000 deposit, which I put into my trust account in November, and they didn't call me. But then I got a W-9, or what is it, whatever the tax form is, saying that they'd paid it. And then I finally got work in February or so, and I earned it. And so I just got a notice from the IRS a couple of days ago saying that there was an error in my tax return because I hadn't paid tax on that $7,000 in the 1 year. And, you know, I think when it's earned or when it's received and when you can deal with it is something that really hasn't been thought through in terms of, is there an adverse consequence to a client or to a lawyer? So.
Yeah,
that's
no, I
something we gotta
agree.
think
I
about.
mean, in a case that I had where I saw a flat fee, it was paid at the first of the month for the rest of the month. That would go into the operating account. But then, you know, is that, you know, when you're putting in the operating account, is that an adverse pecuniary interest because you haven't performed any work? Whose money is it? You know, have you earned it? And I hadn't thought about taxation issues, and I truly do not want to go into tax issues on this opinion, but so anyway.
I mean, there's obviously
Yeah.
some significance to what you do with it when you stick it in one account or the other, which hadn't been nailed down so far as I've seen.
Yeah, so it seemed like there was some give and take when the Rules Revision Commission went through this, and, you know, to use Joel's words, I'm not sure it was all completely thought through, and it creates some issues. And I guess the question I'm struggling with from the, you know, is the standpoint is how much do we want to jump into this and try and, I guess, explain or augment what the black letter rule of the law of the rule says. So anyway, food for thought for, I guess, for June 3rd.
Sounds good. Any other comments for today about the flat fee opinion?
I just have one minor comment, Ken. And it's on lines 71 to 78. I don't know if we have the red line that I was looking at. Let me just pull it up on my end real quick. It was just where you were explaining that in the past, it was common for flat fee agreements to state the fee was paid in advance and fully earned when paid and was non-refundable, and that those types of provisions frequently led to disputes. And you cited to one case as an example. And I agree with that. I just thought it might be helpful to include one other case example if you could to support that. Just because we're saying it's, you know, this was common and frequently resulted in fee disputes. So if we could have just one other after the CEG site here, one other site, I thought that would be
I'll see if
useful.
I can cook what I mean, when some of what I was talking about there was fee arbitration experience.
Yeah.
There were, you know, a number of, you know, fee arbitration cases where, you know, this was the issue. The lawyer was terminated and didn't have the money.
Yeah.
I've seen those go all the way up to the enforcement, you know, phase of it where, you know, the lawyer's going to have their license pulled or suspended for non-payment of an award, ordering them to refund $1,000 from a flat fee agreement that, you know, they were ordered to refund. And, you know, it's gone that far. But yeah, I'll see if I can find another state bar or the case that talks on that. So.